During the pregnancy of this, respondent died.
So you have
I filed application of substitution.
you have filed a substitution?
Yes.
Yes. It will appear under the heading application, Mr. Prasad.
On this application, paper book is ready. I have a direction to paper book. It has been prepared. So I want to let it be come in to be mentioned. We will file the paper book.
Very well. Let it come as to you. To mention.
Oblige, Your Lord.
Thank you. Yes.
My Lord, I am for the petition.
Right.
वो याद रखना तुमको. Yes. My Lord, I have concluded my argument. This is that matter, my Lord, where the order of the disciplinary authority and the appellate authority was set aside, but the matter was relegated back to the. And I say that even on merit.
Sum up your points, Mr. Kumar. You just take a note. You can just sum up your points once again.
My Lord,
Yes, just points.
my point is that, my Lord,
Mr. Kumar, please take your seat. Will come. Yes.
case was initiated against me on the premises that I was in possession of liquor, illicit liquor, whatever maybe liquor, and on the basis of that, I was suspended, followed by disciplinary proceeding in which I was dismissed from service.
Right.
But after my dismissal from service, when the appeal was pending, I filed an application before the tribunal stating that the appeal is pending from an indefinite. So that may be disposed of within a time frame, my lord. While application was pending, the appeal was disposed of. It was acquitted from the charges in the criminal case. So the tribunal said you consider this aspect that already has been acquitted from the charges. So you may take into account and pass a fresh order. That was the order, my lord. Both the authority did consider the authority, and both the disciplinary authority and the appellate authority has passed an order. The dismissal was affirmed, my lord. I challenge it before the tribunal. Firstly, on merit also, my lord, it's against the disciplinary proceeding because all police witnesses, contradictory witnesses, no witness, nothing. This was first point. Second, my lord, in the department for the same allegation at different point of time, different constable and head constable who were involved in liquor excess quantity, my lord, they were given punishment, and therefore the punishment was disproportionate. This was the form of argument which we have made. In the midst of it, when the matter was pending, the Honorable Supreme Court has said that if on identical charges, disciplinary proceeding held the person guilty and subsequently it was found in the proceeding, the case was not proved, it had a different dimension altogether to look into. And therefore the Supreme Court has caused the on the premises that in criminal case nothing has been proved. So on these two four, I have argued before the tribunal, allowed my application as both that my conclusion, first aspect of my case was that an identical fact, judgment of Ramlal will come into play. Once I am acquitted in the criminal charges, the court has to consider, the department has to consider it. This aspect was not considered, my lord.
Thank you.
Also, my lord, I have relied upon similar circumstances, my lord. That, my lord, in another case, my lord, that I have included.
Give us the page number only.
42, my lord. Recently, my lord, in the month of March, this court has passed an order in similar circumstances, my lord. Page 242, 27th of March, 2026.
Right.
Here, my lord, in 246, on the same proposition that if identical witnesses, identical charges, then page 246, my lord, relevant paragraphs were quoted.
Yes.
And in this case, my lord, the court has said that it cannot be relegated, and the court passed an order. Once it is set aside, the court directed to provide all the consequential benefits, my lord.
Thank you. Yes.
May I please, Lord.
Yes. Please.
My Lord, may kindly come to the impugned order. My Lord, this is lordships are sitting on a judicial review
Yes.
of an order passed by the tribunal. Whether the tribunal order is required to be a judicial review or not, that has to be decided first, my Lord. My humble submission is that, my Lord, if my Lord will kindly come to the impugned order, whereby the tribunal, the grounds which is raised by the appellant before the, rather the applicant or the petitioner hearing before the tribunal, that was duly considered by the tribunal. But they made an argument before the tribunal that the same similar person, like the allegations like contained against the petitioner as well as the police persons who was holding an IMFL illegal bottles of IMFL bottles. So they have been given a lesser punishment. Why that should not be accrued to me, because I am also holding that same bottle. So as such, lesser punishment has to be imposed. The honorable tribunal, taking consideration of that submission, has passed an judgment saying that the matter has to be relegated to the other, because rather the disciplinary authorities order has not been set aside. It is an appellate authorities order has been set aside, and the matter was relegated to the authorities to consider the punishment based on the observations made by the tribunal. Not the issues with regard to Ramlal, as they have been raising before this honorable court, that has never been raised before the tribunal. If my lord will see entire order, nowhere the issues with regard to Ramlal has been adjudicated before the tribunal.
Mr. Kumar, isn't a question of law? I mean,
Yes, my lord, because I mean to say, my lord, because lordships are taking a matter on the basis of judicial review, because that has never been agitated before the tribunal. They are first time raising before this honorable court. But my humble
it is a factual question. You are absolutely right.
Right.
But all on the merits of the case, the facts, the evidence.
Yes.
But this is a proportional of you are supposed to know the law.
Yes.
And if you prefer a challenge against our order, suppose to the Supreme Court, you are supposed to know the law. If you pass the order contrary to that, then
About lordship, this is my humble submission. Lordship may
right.
kindly
We
take
were
note of
talking
it.
at submission. Yes.
My lord, the aspect which is taken into consideration before lordships was whether the punishment which can be imposed can be relegated to the authorities or not. They say it cannot be relegated to the authorities. Once a prima facie appeared before the court that there was sufficient material to show that they have not been found to be guilty of an offence, it should be not relegated. Not my humble submission before lordships that
Where is the impugned order? In which page?
Lord, it is at page 236 it starts, my lord.
Yes.
Page 240 is an operative part, my lord.
Yes.
May I read, my lord?
Yes. Yes, please. Para 10,
Para 9 and
9 and 10.
yes. Further, the perusal of charge sheet, it is noted the allegations only to the extent that he was found to be in possession of 40 numbers of bottles of IMFL and he was arrested in a police case. Therefore, in our considered view, the aforesaid cases are squarely applicable in this case, that the order of the disciplinary authority, which was merged with the appellate authority order dated 2nd February 2021 is quashed and set aside. We remand back the matter to the respondent authorities, and here we directed to reconsider the case of the applicant for imposing any lesser punishment than the dismissal or removal.
So you say the remand was only for the purpose of imposing lesser punishment, which is within the domain of the authority.
Yes, ma'am. Because
But in principle, it was set aside. They could not, their dismissal was set aside.
No,
They cannot be dismissed now.
yes, sir. But as we have not challenged this order, so I cannot
Yes,
argument
sir.
that, but being it should not be good.
It's only for the purpose of lesser punishment? Yes.
They are saying, look, I again, board or lordship, we kindly come to, the judgment was passed on 23rd March 2026. And the duration given by the tribunal is 2 months. 241 is a page, Lord. The tribunal said within 2 months you have to take a decision. The punishment, if a lesser punishment has to be done, but it is a clear cut order. The tribunal has not said either to consider. The tribunal said give lesser punishment.
This is one aspect of the matter.
Yes, yes.
We are taking this one. And on merits also, Mr. Kumar is challenging that it should
Yes,
be
yes, sir.
said altogether.
It says that
No punishment.
no punishment. On merit I am coming here. Lord, the aspect with regard to the merit, Lord, I again submit because lordships are handling the issues as a judicial review. In the disciplinary proceedings, the Honorable Supreme Court has categorically held, my lord, that the powers of the court, while considering the punishment, is very limited because the authority, the disciplinary authority and the appellate authority are the competent authority who are judging within evidence because who are based on the materials after scrutiny all the documents, they are imposing a punishment. The court at the far can only interfere when there is a violation of principle of natural justice or there is a procedural error or which found that there is a grave misjustice has been done to the persons, the petitioner hearing. But the instant case, if duly processed departmental procedure was enumerated, he has given all the notices that rather the procedure which has been followed in the disciplinary proceeding are fulfilled. He has never agreed by the procedures which has been enumerated in the disciplinary proceedings. He has accepted the procedures which is followed in the disciplinary proceedings. He has duly participated. And the evidences have been cross-examination by the petitioner. Rather than that, he has been given an opportunity to give an evidence on his behalf, but he has refused to give any evidence. Because I have not taken to that inquiry proceedings, but not as already my lord has gone into that aspect. But once when he has participated in the disciplinary proceedings, he has duly cross-examined the witness. Based on the materials which has been available before the disciplinary authority, he has imposed a punishment.
Mr. Kumar, we are pinpointing our question.
Yes,
because you're right, due process has been followed. Yes. If there is perversity, on the materials which are there without reappreciating, if we are of the opinion that there was perversity in the findings,
yes,
then can't we interfere under judicial review also?
Not
perversity in the sense we are also clarifying it.
Yes,
that here only police witnesses one,
yes,
the other infirmities which are argued by Mr.
Yes,
so you also deal with that.
Yes, not their only
chance.
I'm sorry.
Yes.
Their only contention was that as I have been acquitted from the criminal charges, so the disciplinary proceeding which has been punishment imposed on the disciplinary that has to be reconsidered because I have been acquitted of the charges. At the charges, the allegations contained in the disciplinary proceeding are the as well as the criminal proceeding was same. This was their argument. Not with due respect, because here the disciplinary authority has imposed a punishment because he being an home guard working under the disciplined force, handling around 45 IMFL bottles, madam, and that to be in a restricted area, which is a Jarwa Car Nicobar. Lordship knows. It is in Car Nicobar, my lord. And the persons, rather, the references given by the tribunal saying that the already 4 or 5 bottles which has been carried by the person who has been given lesser punishment, it is a different aspect because as I have not challenged the impugned order, I have not argued on that.
So you said the gravity of the offence
is
higher.
Higher because he has carried 45 IMFL bottles, that to be in a Nicobar Zero area. Lord, he has been in the bus while he was holding it, that bags, it has been seized.
Was he holding it or it was found in the
found because some of the witnesses, in the disciplinary proceeding, I gone to the witness. 2-3 witnesses says it was in the he was sitting in the before him, it was there. One witness says it was seized from him. So there are contradictions. There, don't record what is there. I'm just pointing out. But my lord, the moot question whether it was seized from his possession, that has been proved in the inquiry because he could have been produced an evidence that it is not in my possession, it is not belongs to me. Then opportunity was given to him before the disciplinary authority. He choose not to adduce any evidence.
And you said he belongs to the disciplined forces, the standard should be high.
Yes, my lord. It has been the disciplinary authority imposed punishment basically on the dereliction of duty misconduct because he being a disciplined force, that the charges of criminal cases are different. Because here the only aspect why he has been dismissed in service. He was dismissed because he is being a disciplined force, he has done the dereliction of duty and the misconduct was conducted because being a police authorities or being a home guard, he could not take advantage.
Since you are arguing, we are putting a question against you.
Yes.
Now, yes, we appreciate that standard should be higher, but don't the foundational aren't the foundational facts required to be proved to impose something higher? The foundational fact that has to be there. then we can consider yes, gravity of offense and other.
Lordship is saying that when the basis has to be proved, because the basis has to be shown that there is a gravity.
Yes, which are striking us at the outset,
Yes.
which have been argued.
Yes.
One is that only police witnesses where in remote places we can understand. You know the law.
Yes.
But in this place was public, admitted, there are other passengers, not a single other witness, independent witness, one. Secondly, the contradiction in your evidence also.
The witnesses, there are two aspects. Lord, I just show
Yes,
this
please,
exception. One second, judgment. So. Hey. Now.
So, Kumar, if you can give a copy to your learned friend, then
Yes.
we-
No, I have received my lord.
My lord, I trouble lordships
Yes,
towards para number 16, my lord.
paragraphs. Yes.
Lord, this is a judgment whereby the Supreme Court has said the powers of the tribunal and the Honorable High Court while deciding the issues with regard to the disciplinary proceedings. My lord, I will read lordships para 12. It is quoted, my lord. It is a three judges bench, B.S. Chaturvedi. Judicial review was not an appeal from a decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives a fair treatment and not to ensure that the conclusion with the authority reaches is necessarily correct in the eyes of the court. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is concerned to determine whether an inquiry was held by a competent officer or whether rules of natural justice have been complied with. Whether the findings or the conclusions are based on the same evidence, the authority entrusted the power to hold inquiry as a jurisdiction power authority to reach a finding of the fact or conclusion. But that finding must be based on some evidence, neither the technical rules of evidence nor the proof of fact or evidence has been defined therein, applied to the disciplinary proceedings. When an authority accepts that the evidence and conclusion receive support, therefrom the disciplinary authority is entitled to hold the diligent officer is guilty of the charge. The court tribunal in its power of judicial does not act as an appellate authority or reappreciate the evidence and to arrive at its own independent finding on the evidence. The court tribunal may interfere where the authority held the proceeding against the diligent officer is a manner inconsistent with the rules of natural justice or violation of statutory rules prescribing the mode of inquiry, whether the conclusion or the finding reaches by the disciplinary authority based on no evidence. If the conclusion or the finding be such and no reasonable person could have been ever reached, the court tribunal may interfere with the conclusion of the finding and more the relief so make it appropriate to the facts of the case. But this has been decided by the court that powers of this honorable court while interfering the judicial tribunal. But I like to take lordship's kind attention towards para 19. Lord.
Yes. Yes, please.
Yes, my lord. Despite the well-settled position, it's painful, disturbing to note that the High Court has acted as an appellate authority in disciplinary proceeding, reappreciating even the evidence before the inquiry officer. The finding of charges was accepted by the disciplinary authority and was also endorsed by the Central Administrative Tribunal. In disciplinary proceeding, the High Court is not and act as a second court of first appeal. The High Court, in exercise of its powers under Article 226 to 27 of the Constitution of India, shall not venture into the reappreciation of evidence. The High Court can only see whether the inquiry is held by the competent authority. The inquiry is held according to the procedure prescribed in that behalf. There is a violation of principle of natural justice in conducting proceeding. The authorities have disabled themselves for reaching a fair conclusion by the consideration, extraneous or evidence and merits of the case. The authorities have allowed themselves to be influenced by the irrelevant or extraneous consideration. The conclusion on very face of it wholly arbitrary and capricious. No reasonable person could have ever arrived at such conclusion. The disciplinary authority has erroneously failed to admit the admissible material evidence. The disciplinary authority has erroneously admitted inadmissible evidence and influenced the finding. The finding of is based on no evidence. The Article 226 of the Constitution shall not reappreciate the evidence interference with the conclusion in the inquiry. In cases, the same has been conducted in accordance with the law. What is the adequacy of the evidence, gone into the reliability of the evidence, interfering if there may be a legal evidence on which finding can be based, correct the error fact, however grave it may appear to be, go into the proportionality of punishment unless it shocks his consciousness. But the tribunal, which was adjudicated before the tribunal has taken reference of previous orders and it says that the punishment which is imposed is higher in that disappropriation, so the tribunal has followed
That option goes out.
Yes, yes. Lord, in the instant case, exactly, my lord, the Honorable High Court has given the benefit, as the Lordship saying the point with regard to the evidences, whether the base is not there. But the Honorable High Court has said, no, there is no evidence which cannot be conclude that you have been found to be and charges against you shall be proved. But the Supreme Court has said the disciplinary authority as well as the criminal cases are entirely different nature, because it is a misconduct done by a person being a discipline force. Here he is a discipline force, he is doing in a discipline force. So, my lord, an opportunity when he has been given to defend himself before the disciplinary authority, when he has failed to do so, then he cannot take the plea at this stage, saying that the evidence which is proved was not proved against me. My lord, para 23 of the judgment, my lord.
Yes, please.
Applying the law laid down above, the instant case whereof the view the High Court not to have interfered with the finding of the fact recorded by the disciplinary authority charged were levied against the respondent pertain to a negligence and dereliction of duty attributed to him for having failed to prevent theft of 800 kgs of copper wires laying at Alif Nagar Scrap Yard under the security cover and performing the duty in later hours 7 November 2000 up to early hours 8 November 2007, record review the disciplinary immediately examined the entire evidence brought on record, including the deposition of 88 prosecutors. Each of them have corroborated the charges levied against the respondent. Duly supported by the document and circumstances evidence for arriving at the conclusion that Article 1 should prove against the respondent. Patently, the respondent did not produce any defense witness and documents produced by him did not prove against in his favor. Para 27, The division bench went to step further and proceed to reappreciate the evidence and observe that it was persuaded to conclude that such a major theft of 800 kgs, 42 bundles of copper could not be happen in the blink of an eye lid. Despite holding that in view of the surrounding signature regarding non-production of original beta book as unsustainable, the court held that the allegation of connivance in the theft levied against the respondent was presumptive and there weren't enough evidence to conclude that the theft of such magnitude could have been happened during the duty period of the respondent alone. Yet charge pertaining to the negligence and dereliction of duty on the part of respondent was sustained. At the same time, the order passed by the learned single judge directing the substitution of punishment or disposal with that of a compulsory retirement was set aside and the respondent was directed to reinstate in service with full back wages, while giving liberty to the disciplinary to issue a fresh order of punishment commensurated to the negligence and dereliction of duties on his part, except for the punishment of dismissal or removal from service or compulsory retirement. We are unable to comment the approach of the single judge and the division when there was no good reason for the High Court to have entered the domain of the factual aspect relating to the evidence recorded before the inquiry officer. This was clearly an attempt to reappreciate the evidence which is impermissible in exercise of powers of judicial review, Western High Court under Article 226 of the Constitution of India. We are of the opinion that both the learned single judge as well as the division bench fell into an error by setting aside the order of dismissal from service imposed on respondent by the disciplinary authority and upheld the appellate authority. We find ourselves in competent agreement with the finding written by the conclusion arrived at the disciplinary authority duly confirmed by the appellate authority, upheld the revision authority in respect of both the article of charges levied against the respondent and the punishment imposed on him. The respondent, being a member of disciplined force, was expected to have a discharge his duty diligently. His gross negligence and dereliction duty as a result of theft of 800 kg copper wire from the spot where to be performed his duty. Further, the record reveals the respondent did not mend his ways during 13 years of service rendered by him as was awarded 8 punishment, various diligences out of this, which 3 punishment include stoppage of increment, 2 occasion of 1 without cumulative effect, twice and stoppage of increment 2 without cumulative effect on occasions. In such circumstances, the desirability of continuity of the respondent armed force is certainly questionable. Disciplinary authority could not accept a weaker blinker in respect of past conduct while imposing the penalty of dismissal from service on him. Note para 13. Therefore, it is deemed appropriate to quash and set aside the judgment passed with the division bench of the Calcutta High Court in FMT number 679 of 2019, FM number 680 of 2019, and order dated 20th June passed by the learned single judge while restoring the findings and conclusion arrived at disciplinary authority as elaborated in order 27th November 2008 duly upheld by the appellate authority, order dated 3rd February 2000 and endorsed by the revision authority, dated 19th in our view, patently dismissal from the service imposed harassment is commensurate with the gross negligence, dereliction of duty on his part. Not my humble submission is not this is a gross negligence, dereliction of duty. But with regard to the criminal charge, it is different in nature.
Mr. Kumar, there is a distinction here. We are putting it to you so that you can answer, because we can make out. One is that here it was a case of negligence and dereliction of duty. In your case, but our case, it's a direct involvement allegation. There's a sharp distinction between the two. Yes, we can appreciate police forces, dereliction of duty, other people are trafficking these things, but here the allegation is direct involvement. One. Secondly, here we see the past conduct is also considered.
Yes, yes.
But yes, you are right in saying that that's a secondary consideration. The previous observations are there, cannot be appreciate evidence, and all the other things are there.
No, my humble submission is that not because the reappreciation of an evidence by the tribunal as well as the lordships of what
Two forums, concurrent finding, this we are
that is the only humble
actually 3 forums, including the tribunal,
Absolutely.
because the guilt was affirmed by the tribunal. But let's
My humble submission to that extent only, because
Definitely,
the tribunal has, right or wrong, the tribunal has held it that it should be the powers of imposing penalty, it should be before the appellate authorities or rather the disciplinary authority. Because the as such, the tribunal has said you relegated the matter to the authority. But now their only contention through their argument before the tribunal is also that the punishment is higher in nature. Now they are saying a new, rather a new plea before lordship, saying that so we should be exonerated from all the charges. But why? Because there is no allegations have been proved against them. So this is what a new plea which is raised, because rather it was not decided by the tribunal. As such, my humble submission is not once an order was passed by the tribunal and the powers are absolutely vested upon the authorities to decide the punishment. Because the time provided by the tribunal is still, it's not get over. Though not the authorities has to be taken a decision whether it could be proceeded further or not.
please give us half of. You can put the section section I'm not confused. Yes, yes, it's
not. With regard to the criminal cases and the disciplinary proceedings.
Yeah.
But I'm sorry, Lord, I'm taking much time, Lord. But
No.
kindly come to page number 13.
You are there to argue for your client.
So,
Yes.
my Lord, may kindly come to page number 11, my Lord, para 13. My Lord.
Yes, perfect.
The principle which govern an inquiry as distant from those which apply to a criminal trial. In prosecution of an offence punishable under the criminal law, the burden lies on the prosecutor to establish the ingredients of the offence beyond reasonable doubt. The accused is entitled to be a presumption of innocence. The purpose of disciplinary proceedings when an employee is an inquiry into an allegation of misconduct by an employee which resulted in violation of the service rules governing the relationship of employment. Unlikely a criminal proceeding where charges has to be established behind reasonable doubt in a disciplinary proceeding, a charge of misconduct has to be established on preponderance of probability. The rules of evidence which apply to a criminal trial are distant from those which govern a disciplinary inquiry. The acquittal accused in a criminal case does not debar the employment proceeding and exercise of a disciplinary jurisdiction. Lord, 16, my Lord. Page number 15, my Lord.
Yes.
Para 16.
Right.
In Calcutta, in Karnataka Power Transmission Corporation Limited versus C. Nagaraj, this court has held acquittal by criminal court would not debar an employee from exercising power to conduct disciplinary proceeding in accordance with the rules and regulations. The two proceeding, criminal and department, are entirely different. They operate in different fields and having different objects. Disciplinary proceeding, the question is whether respondent is guilty of such conduct as would be merit the removal from service or lesser punishment, as the case may be. Whereas the criminal proceedings, the question is whether the offence registered against him under the Prevention of Corruption Act established, and if established, what sentence should be imposed upon him. The standard of proof, the mode of inquiry, and the rules governing inquiry and the trial in both cases are significantly distant and different. But why I am showing about there is no debate, they both can parallelly continue. But not the issue with regard to the disciplinary authority and the issue with regard to criminal is entirely because there you have to show it, the burdens upon the prosecution. Here the burdens upon the persons who have been charged with it. 17, my lord. In exercise of judicial review, the court does not act as an appellate forum or the finding of the disciplinary authority. The court does not reappreciate the evidence on the basis of which a finding of misconduct has been arrived at in the course of disciplinary inquiry. The court is in exercise of judicial review must restrict review to determine the rules of natural justice have been complied with. The finding of misconduct is based on some evidence. The statutory rules governing the conduct of disciplinary inquiry have been observed. Whether the finding of the disciplinary authority suffer from perversity, the penalty is disappropriated to prove misconduct. However, none of the above tests for attracting the interference of the High Court were attracted in the present case. The Karnataka Central Administrative Tribunal, having the exercise of power of judicial review, found no reasonable reason to interfere with the award of the punishment of compulsory retirement. The division bench exceeds jurisdiction under 226 and retains upon the domain which falls within the disciplinary jurisdiction of the employer. The inquiry was conducted and upon the principle of the finding of the inquiry officer and the discipline are sustainable with reference to the evidence and adduced by the inquiry. The acquittal of the respondent in course of the criminal trial did not impinge upon the authority of the disciplinary authority of finding of misconduct in the disciplinary proceeding. Lord,
Yes.
my humble submission is not why emphasizing this, lordships, because Lord, the powers to impose punishment is upon the authorities. The tribunal, again, I'm repeating, Lord, I'm sorry, Lord, because I'm repeating again that aspect. Lord, the tribunal has said that you consider the punishment other than dismissal. Rather, it could not be an agreed by the petitioner before lordship because their only intention was the punishment which is imposed was an extraneous, it has to be reduced. The tribunal has rightly said the authorities to reconsider it. But now it has to be taken, a decision has to be taken by the authorities. Whether the punishment which is other than dismissal, what will be the punishment? But my humble submission is that lordships, because the authority, which is the discipline authority or the appellate authority, who can judge the punishment which has to be imposed. The Honorable Court can only look into the aspect whether there is a judicial error or whether it is a principle natural justice has been violated. No, the instant case, nowhere it has been challenge has been made out before the tribunal that there is some misconduct or something with the rules which have been faltered by the disciplinary authority. It has been accepted. They accepted the proposition. This is not recently not. This is the reason. Not here, I will not trouble lordship. I'll just take lordships into kind consideration towards para 29.2 because the aspect which is have been decided as explained in those judgments have been taken by the Honorable Supreme Court. But the Honorable Supreme Court has said not exactly on that point that when you have been acquitted in the criminal charges and previously when the disciplinary proceeding has been taken place and you've been found to be penalized for certain punishments have been imposed, it does not create any right that after a disciplinary proceeding you agitate again and saying that I will be as exonerated in the criminal, I should be again exonerated. So not the Supreme Court of the nature of proceeding being only separate and distinct, acquittal in criminal proceeding does not entitle the diligent employee for any benefit in the later or automatic discharge of disciplinary proceeding. Not with regard to the, as I already said, not I will not trouble lordships towards that evidence. If my lord will see. Not I only I take lordships. Look, only I take lordships towards page number 66
Yeah.
of the.
Sir, page.
Page 66, my lord.
Yes.
Note statement of PC 532 Ashok Pullu. Note question number 3, my lord.
Yes.
You stated in your statement the CEO was not giving any satisfactory answer to Inspector Edith. Then what was the original reply at that time? Initially, CEO refused the ownership of the bags, but later he accepted. Note the bags which was contains the IMFL bottle. So this witness has neither a charge sheeting witness before the criminal.
What
court.
is this here?
No, he's a charge sheeting officer. C is a charge sheeting.
Thank you, sir. Yes, yes.
So, my lord, I will not trouble to the entire evidence, but as lordship says, certain basis has to be there. My lord, the inquiry officer, based on certain materials which is to be taken into consideration, then only has come to a finding of imposing a punishment. My lord, this is my humble submission, my lord. And moreover, my lord, with regard to Ramlal and the judgment passed by our coordinate bench, the facts are entirely different. My lord, I will take the lordship towards the judgment passed by our coordinate bench. It has been enforced, my lord, but I'm just giving the tribunal's order. Because in the tribunal order, they have raised the plea that Ramlal, the factual aspect of Ramlal is squarely applicable. The tribunal has also said that the my lord, may kindly come to page number 9. Page number 9, my lord, para 7, my lord. The tribunal's order. We find that in instant case, the evidence, witness, circumstances were same and identical in departmental inquiry and the criminal proceedings. Therefore, it is squarely covered by the aforesaid judgment and Ramlal Supra. Accordingly, the order of disciplinary authority and the order of appellate authority as cause set aside. The matter is remanded back to the authority, consider the case of the applicant, take into consideration of the order of acquittal from the criminal case. And as the Ramlal principle has only taken into consideration, the authority is further directed to communicate this decision of way of reason speaking out of the. So they said instead of consideration, why it should be, because then there is a finding of the court that both the factual aspects are same. But what the instant case, if the lordship is kindly peruse the tribunal's order. Tribunal has not said that findings of the disciplinary proceeding as well as the findings of the criminal case are same. The tribunal has only taken into consideration that aspect that the earlier the same similar persons have been given lesser punishment. Why that should not be accrued to the instant petitioner? And the tribunal has passed a mandatory order that instead of dismissal, you have to consider other punishments. You know, the Honorable Division Bench, while considering this aspect, page number 25, my lord, this is at page 252. It starts from 25, my lord. I will trouble your lordships towards 26, my lord. Para number 26.
Yes.
If that be so, we have no justification to tribunal to remand the matter to the disciplinary for reconsideration. In our opinion, tribunal should have merely set aside the order of disciplinary authority and appellate authority. We are in the agreement with the advocate, the petitioner, that a fresh consideration of matter by disciplinary authority will be an exercise in futile, completely unnecessary. In view of the order passed by the tribunal, relying on the Supreme Court decision, the disciplinary authority left with no choice to the matter but to choose a disciplinary departmental inquiry. In our consideration, the writ has succeed and the Honorable Court has said. Here, my lord, the punishment was only a reduction of 2 increments, and it is have to be cumulative effect. Not but in the instant case, the punishment is dismissal of service, and that to be carrying and 45 MFL water at the Java Reserve. The gravity of the offence has to be taken into consideration. This is my humble submission. I vote on it.
Yes.
First of all, put in a line that's made.
Incorrect submission. So far as my lord, this issue was never raised before the tribunal. If my lord sees ground number 2 to 11 before the tribunal, this was a specific issue which has been raised in my original application with regard to the fact that even in the touchstone of preponderance of probability, the case was not true. If my lord comes to the grounds Number 11, of the original application, my lord.
Please give us a page number.
My lord. My lord, it starts from page 35. ठीक है ना? My lord. These dispositions have been dealt with, my lord.
Yes.
Even in para 12 also,
Also, yes.
yes, my lord. Even para 15 also. Now, my lord, I have submitted a written notes of argument before the tribunal. My lord, may kindly come to page 232, my lord. Relevant would be 235 so far as this part is concerned. So far as the merit is concerned, my lord, I have merited the ground. In the position, most particularly to the possession of the alleged bag and the place of seizure. And as said, did not fulfill the requirement of preponderance or probability. No independent witnesses were examined. So, my lord, it was from the inception, these are the twofold grounds on the basis of which the application was passed, even on the text tone of preponderance or probability. Secondly, my lord, the punishment is disproportionate. Now, my lord, just since my learned friend has shown the evidence, I will just show, my lord, the contradictions, my lord. My lord, kindly come to the writ petition. I will just show the relevant subclauses, my lord. 5 and 9. Yesterday, I have shown one of them. My lord, may kindly see subclause N with H, my lord. I'm sorry, I could have taken it in one paragraph. If my lord sees.
You had actually placed in an age.
Yes.
You have marked it, that means you have placed.
Yes.
Main gate and this.
I'm just showing contradiction, my lord. PW in para H says, PW says, in his crossing that the seizure was affected at police station Karankumar. Now, my lord, PW in para H says that the seizure was affected at the main gate in presence of the public. Witness.
N actually covers H also.
Yes, yes, my lord. That's why I could have. Now, my lord, can we see para A, PW1? It says that admittedly the petitioner was not carrying the sealed bag and it was kept in the bus. Page number 5, my lord. Para A. He is also a police witness. What did, my lord?
Para?
Para A, my lord.
A. Yes.
It says that the petitioner was not carrying the seized bag and it was kept in the bus. Now, my lord, we can see para G, next page. PW7, which my learned friend shown. He says that the petitioner was not holding the bag, although the bag were kept near the seat of the petitioner. Now, my lord, PW9, my lord, in para cases, that the petitioner got down from the bus along with the seized bag, which is contradictory to the deposition of PW7 and PW1. Police witnesses, they, as per their convenience, come and make statement before the presenting officer. Can you see the operative portion of the inquiry? These contradictions were taken into account, my lord. It starts from page 70. Relevant would be 79. My lord, can you see the finding of the inquiry officer, my lord?
Yes.
He says on analysis of the following point. The presence of inspector at main gate of Moose Jetty during checking of baggage passenger. The PC number so and so, Whereas Satyavati and PW name is so and so, that she was at main gate of Moose Jetty during recovery of so and so in FIR. So and so reflected that the CEO is hiding himself in the crowd. When she checked the passenger on suspicious, she apprehended him and checked his bag. On checking, she recovered so and so. Due to the contradictory statement of PWs, the presence of inspector couldn't be ascertained at the time of seizure. One of the seizure witnesses stated in his cross-examination that the seizure is affected at PS Karnikova, whereas the other seizure witness says that it was from the Moose Jetty. Then he says with regard to pay slip was kept with so and so, Botal and Caesar together, the Caesar pay. And when see, the basis of this, we are finding that the charges are true. He himself says that there are contradictions. Para 80 Miller, finding. On perusal of the report and so I write. But this finding is for a Miller. Inquiry, imprint was October.
Imprint order.
13 अक्टूबर 2014
और appellate charge करो.
Yes.
Now, my lord, two things they need to prove, my lord. First, I am in possession. Second, it was seized from my possession. Both they failed. Their own witness says. So far as possession, they have two views. Persons. So far as seizure affect the place of seizure, they themselves have contradictory. Under such circumstances, whether it can be said that the proceeding in the disciplinary proceeding, it has been proved and it can be treated as preponderance of probability, it has been proved. It is not there. Therefore, I argue merit and therefore make case on merit. So far as the judgments are concerned, none of the judgments are applicable so far as the facts of this case are concerned. Now, my lord, I am just placing those judgments with learned friend as. And my lord, even in the other case, that is the coordinate bench passed the order, there also both the orders were set aside and relegated back to the authorities to consider what would be the punishment. Or there the court said once the court arrived to a definite finding that both the orders cannot stand, they cannot have an administrative say after the judicial order passed by the court. This was my argument, and the court accepted my argument and said it cannot be. Now, I will see three judgments which my learned friend relied. At first, my learned friend relied upon Subroto Mark, my lord.
We can appear. I mean, we can anticipate what line of distinction we'll be making. So make it short, Mr.
Yes, no, my lord. I will...
So definitely, we anticipate what you are going to say. That's why make it short.
My lord, here, if my lord sees first judgment which my learned friend relied,
yes,
there at para 23, the court has arrived to a definite finding. If my lord see 8th line, it starts from record reveals that disciplinary authority has minutely examined the entire evidence brought on record, including the deposition of 8 witnesses.
We have underlined.
Minutely
examined, corroborated charges, duly supported by documentary. These are the 3 parts.
3 points, and it cannot be. And my lord, furthermore, my lord, I don't think that there was a case where acquittal was there. There was an appellant only.
When you hear either of you also mark the anti-paragraphs. When you cited your judgments also, we have got similar markings. So Mr. Kumar did not worry on that.
So, my lord, here there is, it is not a case where.
You have to balance actually the proposition.
My lord, it is not a case which my learned friend relied where criminal court has acquitted on the same, the disciplinary proceeding was held and there it was taken into consideration. There arrived to a finding. Right. And my lord, this judgment is of November 2022. Now, thereafter, my lord, only judgment, my lord.
That's they were saying that.
Yes, my lord.
No, please continue. Yes.
My lord, the second judgment, state of Karnataka versus Umadvi, there the disciplinary proceeding saying that they won't have the power. We are having para 17 if my lord sees. Para 17 if my lord could have definitely marked it. The court said, my lord, these are the parameters which are to be considered. The court said the finding of misconduct is based on some evidence. Para 17, my lord. Secondly, it says the statutory rule governing the conduct of the disciplinary inquiry had been observed. Statutory rule also says that there must be an evidence of preponderance or probability to prove a charge in a disciplinary proceeding. Thereafter, whether the finding suffers from perversity, what has been found from my lord. So exactly this judgment will come to my aid, my lord. So far as the preposition is concerned. But in that judgment, the subject matter was whether the authorities have a power to conduct a disciplinary proceeding only because a criminal case was initiated, whether it can be done or not. We are not in whether the authorities have power, and we say that authority is definitely having a power. Now, my lord, so far as the last judgment which my learned friend relied upon, my lord. Now, my lord, here
This is on the distinction between a criminal proceeding and a disciplinary
well,
proceeding.
here
Preponderance of probability and
we are to this level.
yes.
My lord.
So this is on that.
Yes.
But you say that even if it's on preponderance of probability,
Yes, I say, my lord, that judgment is not applicable in my case. Para 17 says these are the parameters which are to be proved in a disciplinary proceeding. Para 17.
yes.
I am only on that. This judgment is not applicable in my case. But the court says even the what are the parameters which are to be proved in a disciplinary proceeding.
Yes.
Our judgment which my learned friend relied upon, para 21 says, my lord, it is not that
The tribunal.
my lord, the State Bank of India. My lord.
Yes, yes.
Here, para 17, the court said, only because a criminal proceeding is pending, therefore there is no automatic stay of the disciplinary proceeding. My lord, there are two lines of judgment. Though this is not applicable in my case, there are two lines of judgment. Some judgments say it had to be, some judgments say it not. When it ought to be, the judgment says when it is the charges are identical, it can be. There are judgment on both. No, this is not applicable in my case. And para 29.2, the conclusion which has been arrived, it says that only you have been acquitted in a criminal trial. That doesn't mean it would be automatically that the disciplinary proceeding will be. Exactly says, my lord, once a person is acquitted in a charge where the disciplinary proceeding is on identical charge, identical witness, then it has a different dimension. The court has a power to consider it. When on similar set of witness in a criminal charge who has been acquitted, under such circumstances, the court enjoys the power to reappreciate the evidence to come to a definite finding whether it can be or not.
So closing arguments. Our learned counsel of the parties, who serve, the matter is reserved for judgment.
Okay,
Very good arguments by both of you. We'll be sorry for the person who loses. But
We are thankful, Lordship.
no question of that. Yes. Next one. Sorry.
I am appealing for the petitioner, madam.
Mr. Singh also.
Yes.
For Rajni Devi. Achha, what about this? We parted with the matter by you saying that Rajni Devi has got benefits.
Yes, yes, no.
So why are you challenging?
No, she got the benefits only in respect of his salary fixation and also that she has been considered under the old pension scheme. At that point of time, when she got the order, she had challenged that in 2016.
ऑर्डर लेके आया
Only a small मिला नहीं यार मुझे बोलना पड़ेगा. I'll make only a small solution. In the case of Rajni Devi first. If you look at the order which has been passed by the tribunal.
Mr. Kumar, Mr. Singh, and also Mr. Mal, in this matter, we'll request you to file bullet point notes of arguments.
Yes.
Because we are hearing it over 2 days, and there are certain points which we anticipate that we may miss out when we pass the judge. So we'll request you to file bullet notes of arguments on Monday. We have some time still.
We'll do it. We'll.
So bullet notes of arguments, just the main points, and the reference to the pages will help us if necessary. Both sides. And Mr. Kumar and Mr. Singh, the petitioners, if you can please ask your learned juniors to just collate, I mean, so that there is no common arguments. No, we are not passing. So that there is no common, so they can segregate the additional arguments.
Yes, ma'am.
Because there are certain additional points in your case, probably. So the common judgments we'll find from your notes of arguments, and if you collate between yourself, the additional points we'll find from Mr. Singh's.
Yes, ma'am. That will.
In the case of Rajni Devi,
Yes.
there are 8.7. There is 199 Rajni Devi WPC.
Yes. 190.
8.7.
Oh, sorry. Went the wrong one.
Order passed impugn orders, which is under challenge.
Yes, just
This
wait.
is a common order in the case of Savila Manu and Rajni Devi.
Sorry, I was looking at the other file. Which one is the Rajni number? 7?
WPC number 7 by.
Last
Not same judgment.
Same judgment.
Same.
page is not different.
Case is
Sabina Banu can not be referred. Same.
No, Mr. Singh will again revert back to that, so let not take the risk. Page 199. That is why we requested them to collect their
Yeah,
written
we'll
notes
do it.
so that it refers to the same page of one of the
Yes.
writ petitions. That will be easier for us. 199, Mr. Singh,
8.7 paragraph.
8.7, right?
Applicant in OA number 351-1428 of 2017 has also challenged the assessment of the vacancies existing on 11/6/1997. Records reveal that vacancy was assessed by administration in an administration letter to the UPSC dated 18/2/2023. Neither this letter was challenged within the stipulated periods, nor it is under challenge in these rules. This challenge of assessment of vacancy as on 11/6/1997 is thus barred by limitation. Now, this is the tribunal itself says this is a letter which has been written by the Andaman Nicobar administration to the UPSC. It was not communicated to me at all. When I came to know about this letter has been written, it will reveal from the page number 105, rejection order. 105. Not 105, but sorry. Just a minute.
Yes, take it.
Just a minute. This is at 144 by 144. Order number 3581. 7th of November 2016.
This is 16.
16.
Right. It's a bit, yes, right.
From this letter, I came to know that administration has recommended my case as it appears from page number 147. And whereas the administration has requested the UPSC to regularize the above doctors ad hoc service on the subsequent vacancies created by the administration on 16/2/2099 white administration letter number such and such and the binders issued to the UPSC. And from this letter further it appears that UPSC has not accepted the recommendations of the Andaman Nicobar administration. Now, my respectful submission is 4 vacancies were created on 16/2/99. Expansion of vacancies. So 15 homogeneous group of 15 group that will apply to these also. I may have been selected in terms of 1997 rules. But since I belong to the same homogeneous group, I could not get selected in that first round. That's why I participate in this. And the order which of participation which they have shown yesterday of 2006. There is no question of giving any willingness to participate in 2006. They have obtained it in 2015 only before attending the interview. Another point is, my lord, just for a minute. Kindly come to the page 105.
Yes.
On the basis of the recommendation of the selection committee, the commission approved the following offers in order of merit. This is very important. In order of merit. Now, 3 candidates. That serial number 6, Charles, he is a ST candidate. He comes in order of merit above the general category candidates. So it means they have been selected on the basis of their own merit. Then how they have selected 3 candidates more? They should have been treated under the general category. As for the law, well settled law.
This 6 should go to the reserved category and then therefore this becomes vacant.
Yes.
So everybody goes up 1 rung.
One. Because in the Sami's case, 1993, which clearly says were held reserved category candidates who are selected on the basis of the merit.
You better cite formally in the SAN.
Why?
Please cite formally in the SAN. Give us the references so that they can answer on that also. Because here in the SAN will be relevant.
This is 1.5. As far as the vacancy assessment is concerned, kindly come to the page 40 of my application. Paragraph 20, page 42 of my original application.
Page 40?
42 of my application,
Right.
para 22, 21. Application which was filed before the tribunal.
Yes.
Para 20.
Para 20.
That admittedly the requisition for the recruitment of 24, 16 UR and 8 ST candidates for the post of medical officer was sent on 15/1/2001. Here I want to make a respectful submission that after 2nd July 1997, post-based roster has come into existence, become operative. Now, they have sent a requisition of 16 unreserved category and 8 ST candidates. 24 posts were advertised by advertisement number 14, item number 3 of 2001, but the recruitment process was withheld due to litigation till 30th December 2012. that prior to the commencement of the ANN Health Service Rules 1997, which came into force with effect from 12/6/1997, according to the respondent administration, the total number of vacancies was 16, 12 plus 4. 4 posts were created by the Andaman Nicobar Administration in 1997, order dated 16/2/99. Therefore, at the time of sending the requisition on 15/1/2001, the vacancy was as under. UR category 12 as existed on 2. At that time, they were not filled up. 4 vacancies existed prior to that 12/6. Now 4 vacancies were created subsequently.
This probably C we cannot go into.
Hmm?
C probably we cannot go into because that is
See,
post.
I'm not going.
A and B are there.
A and B are there.
Yes.
Because the 4 were created subsequently.
That's why.
Order is there. Now, my respectful submission is that as for the roster, 3 earmarked posts for ST category at serial number 1427 and 40 were duly held by Dr. Titus Elfin, Dr. Anwar Musa, and Dr. Nichols, all ST candidates on regular basis in the service. The date on which the requisition was sent. I have annexed that document also, which I have obtained under RTA.
Hmm.
And this is at page 129. 129. Folded papers are there. Particulars of the post filled in through permanent or ad hoc appointment. Serial number 14 is ST candidate Dr. Titus Elfin.
Yeah, the tick marks are there. Yes. In our copy also tick marks are. Yes.
That's it.
What is 44 is general.
44 is
The tick marks will look at the tick marks is obviously, but 42 is also ticked. That's general. So we'll see. We can see very well what the ST.
3 were there.
See what there.
And they are not resigned, they were in service when the requisition was sent. Now the question arises, how they have come to a finding that they were having the 8 vacancies of ST candidates.
But they were working in the regular
And what
category.
they have answered, their answer may be seen by
They were working in the regular category. You have stated. Also, they were ST candidates.
ST candidates regularly appointed.
They were-
Until unless they resign or they go away, no vacancy will rise, post is no,
They were already working there in general.
working there.
So
on
you
that
cannot put
day.
them from somewhere and say that it's a vacant post. You say that. They were working, principally you are right, Mr. Singh, that they were ST candidates should have been put under the ST head,
Yes,
but they were already working under the general category. Then new posts would have to be created. But the direction of the tribunal was that whatever was the position,
no,
those posts were not actually vacant. De facto,
it
not
was not
vacant.
vacant at all.
So therefore,
How they have come to a finding, sending a requisition for 24 vacancies, 16 for UR and 8 for the ST.
let's see their reply, you are placing their reply.
Yes, madam. Their reply is what they have stated in their reply, just
Yes.
Yes. It's 156 file.
Yes.
This is 156 paragraph, bottom
Yes.
paragraph 19.
Paragraph
19.
19.
For the contents of para 20 of the OA, it is submitted that 8 posts of ST results against the 24 vacant posts of MO is due to the carry forward of the backlog vacancies. Where from these 4 backlog vacancies have come? As a matter of fact, the tribunal ought to have decided all these issues. This is on record. They simply said that I have not challenged the letter dated 18 February 2013, which is a letter which is written to the UPSC. That is never been communicated to me. It has been communicated to me when my representation was rejected. This is rest of the things I have already submitted.
Adopted. Yes.
And one more point, my lord.
Yes.
UPSC recommendations are not mandatory. These are directory. Because already the Supreme Court has held in the case of Jitendra Kaur versus State of Punjab, 1985, volume 1, page 122. I'll produce the judgment. Where the selection made by the UPSC has to be complied with, but it is not mandatory. It is only a directory. And if the authority government is not following it, then they have to place it before the House, on the table of the House. The reasons for not complying with it. It is clearly cut held in that judgment. I'll annex it with my written also for the point.
So kindly come to page 157, paragraph 20.
Yes.
Did you say for this? Because when you were appointed for the post of that, your MOs on the short-term basis, it was considered to be a short gap or a stopgap arrangement.
No, I was appointed on ad hoc basis against the clear-cut vacancy.
Page 157, there is a paragraph.
157.
Yes, Mr. Singh.
Paragraph 20.
The leadership
That
is
you have
asking, yes.
been appointed as a
Yeah.
stopgap. Was that a stopgap arrangement?
No, my lord.
So even if you have been appointed
No.
on ad hoc basis, does it confer any vested right?
No, if I have continued and if I have discharged the duties, definitely I will have a right to that. Because what the tribunal has said, you assess the vacancies on 12/6/1997. And their cases should be considered in terms of 1984 rules. They have assessed the vacancies that they said they have got 12 vacancies for the unreserved category and 4 vacancies for the ST category.
Yes, on the last occasion, you were questioning with regard to the number of vacancies.
I'm questioning that also.
And that is the challenge you are throwing.
That was the challenge before the tribunal. And the tribunal said, you have not challenged the letter dated 18/2/2013. And it is time barred.
That is the tribunal's finding.
Finding. That is the incorrect finding. Because I have
And you
come.
were not aware of that 16/12/93, that letter.
No, I was not aware.
So did you bring it to the knowledge of the tribunal at the time of hearing that this particular letter was not even?
I have got everything and they have simply said in one paragraph 8.7 that he has not challenged it and it is
He has
time
not.
barred. He has not challenged that letter and it is.
That letter.
That letter which they have written to the UPSC.
Letter.
Internal.
To UPSC and authority. Direction to those who should answer in future and the constitution of the person.
Subject to. যেটা পাবে সেটা ফলাফল হিসেবে এটা পাচ্ছে যদি আমরা ছিল সেটাও আমি চালার জন্য
Mr. Singh, according to your calculations, what should have been the actual vacancy position on that date after deducting everything? Just give us that numericals.
Actually, when I was appointed in 1995,
No, not that. We are saying as on that cutoff date, that June 1997. Because you have thrown a challenge to that also before the tribunal, that the vacancy position given by them was not the actual vacancy position.
yes, my lord.
So what are the numerical, the numericals, exact numbers? Please, can you give us that? Or you can give us that in a chart?
I'll just
Give it in a chart so that we want to know, because three of you are there.
yes.
We'll have to calculate 12 posts. As per the authority, the Andaman authorities, 12 posts were there. Therefore, you three were left out, merit list and whatever. On argument, merits, it's a different argument. But if we calculate and find out,
Even otherwise also, my lord,
three positions were
three
there,
ST
then all
candidates.
yes.
three ST candidates have been selected on the basis of their own merit.
Therefore,
They have
these three-
appointed three general category.
so these should
Only
be
9
shown as-
candidates out of 15 should have been selected. Only 9 general category candidates out of 12 could be appointed. That itself is wrong. When they say in order of merit,
only 9 candidates.
only 9 because 12 vacancies were there. 3 candidates, ST candidates.
That does not help you in any way.
No, they will be accommodated against what? Unreserved vacancies. So they will come and apply the 3. 9 vacancies are left. It is a case of discrimination, something wrong has been committed by the administration.
But you're trying to cut off the branch on which you are sitting also.
No,
Like
Why?
Kalidas, sort of.
no.
If 12 becomes 9, then you are also affected. Everybody is affected.
I am already affected, my lord. I am already affected.
Hmm.
Something has to be done in the context of the law.
Very good. Very good.
Now, in the case of procedural, very small arguments, my lord. Kindly have a look at the order which has been passed by the tribunal. In my WBCT number 6.
What is
আমার কি কতগুলো missing pages ছিল আমাদের লিখেছিল আমার 10টা missing pages ছিল সাইড পাঠিয়ে
কোথায় আছে?
that has been
Yes,
Thank you.
I'm grateful, my lord.
No,
Sorry.
it was not challenging myself.
Yes, Mr. Singh.
The order starts from page 135, my lord. And below portion is paragraph number 7.
Portion for 6, 135 at 135.
First, they have extracted the prayer. One of my prayer is that
Number missing.
Oh, no, 150.
There are 2 volumes.
Two volume in my petition, there are 2 volumes.
Here also the pages are missing.
So in my books,
This is what the owner. The main and I read application to be. Which is 6.
6.
WPCT 6.
Yeah. Yes.
First, they have extracted the prayer which I made in the application. The first prayer is
Yes.
that I should be allowed to continue in terms of the earlier order or adjusted against the vacancies which were
You're placing
created.
paragraph 6.
Paragraph 2, well,
What?
page 136.
2. Yes.
Got it, my lord?
Yes. 136.
Paragraph B. Second paragraph here is that I have asked for the leave period of 16/11/2008 to 31st of October 2011 to be regularized. And after in paragraph 4, the tribunal has given in its considered opinion, issues listed above are distinct from each other and cannot be subject matter of a single hearing as per the rule 10 of the court procedure rules. This which demands the plurality of the relief in application. For this reason, OA is liable to be dismissed. Now, in this case, they could have very well asked me to
Put in additional court fees or file another.
another application.
Not press one on the pair. Immediately.
And the second stay for regulation has been set aside on the same grounds. Grounds which have been taken in the case of Sabila Banu and Rajni. Only one order I would like to show in this case. Is 112. Of course, it has been annexed here,
Yes.
112.
Right.
When we come to the page 113, this was speaking and reason and speaking order has been passed by the secretary. Considering my grievances, what they have said now, therefore, the grievances of Dr. Srimati Kosa Praveen to allow her to join duty as medical officer in AN Health Department and regulation of her absence from 16/11/2008 to 31st December October 2011 cannot be considered as her ad hoc appointment has been discontinued from 1/10/2009. They say so. And she was unauthoritatively absenting from 16/11/2008. Now, for the purpose of unauthorized absence, the absence has to be decided. Question has to be determined whether the absence is willful or because of some compelling reasons. Now, while applying for the
That has been discussed in the previous paragraph. She was absenting unauthorizedly beyond such and such, and a request for extension of leave was not considered. So you asked for leave, it was not granted, but still you absented yourself. In the previous paragraph, it's considered.
No, in the previous paragraph, such letter has not been sent to me. I have gone to the UK for appearing in the examinations. These letters have not been sent to me.
No, but you made a leave application.
Original application I have mentioned that I wanted to appear for these examinations from the UK.
But that was not granted.
No, they have granted the
Please
leave.
come to the previous paragraph, Mr. Singh. Just the previous paragraph, page 113.
Yes, ma'am.
The paragraph before last, about say 6 lines from the bottom. Even her leave. Even a leave application was restricted to 15 days only, and no permission was accorded to visit abroad. Considering the acute shortage, such and such, she was directed to report for duty, but she failed to report. You were absenting unauthorizedly beyond 16/11. That has been dealt with by this author, by the secretary.
But here in this case, when I have applied for leave,
We cannot reopen everything here.
no, I'm not asking for that, I'm just proceeding. Only for that purpose. Actually, here this is OA 48 has been annexed. In fact, OA 98 should have been annexed, for which I have filed a MA application. That is on record now. In that MA, I have categorically mentioned. Can. Can application, my lord.
You can, isn't it?
Mr. Singh, if you can conclude in a nutshell so that we can take up, just conclude in a nutshell, and we'll take written notes from you.
My question is,
Yes.
I have applied for the leave
Yes.
for 1 month.
Right.
They have granted me the leave for 15 days.
15, yes.
Right? There afterwards, I have asked them to extend my leave. They have not communicated me that the leave will not be granted.
Does that automatically entitle you to the leave?
No, When I have left
Then I will
service,
do that, sir.
no,
I'll write to the authorities, grant me leave, don't grant. I won't.
but in my application, I have categorically mentioned that I want the leave for this purpose.
They've not granted you that. So it's unauthorized, it's palpable. We cannot enter into that in 226.
That is up to your lordship. My question is only, the tribunal ought to have decided this issue.
So Councillor Parveen, an additional point is that leave period should have been considered.
Leave periods should have been considered. Because why I am asking for that? I am around 52, 58 years now.
Yes.
When my service was discontinued on 16/11/2008, when I was 8 onwards, at that point of time, my service, I have rendered 17 years and 8 months service. Now I will not be getting the pension even.
Yes.
That's only one point. Even if they have allowed my rights, unauthorized absence, whatever is, they should have held the inquiry for unauthorized absence.
So that is your additional point in Parveen.
Yes, in the. Because the live will settle starts from Bakshi Singh versus State of Punjab and Man Singh. That issue of unauthorized absence can only be decided if it is decided whether the absence is willful or because of some compelling reasons. They have not extended my leave, but once I have come back, they should have held a proper inquiry and they should have given a finding that it is willful.
Just put in your written notes also. We have.
And it's fine.
Yes,
Always fine.
thank you. Yes,
May not be.
you are for UPSC.
UPSC, it's contrary to-
UPSC.
The petitioner are attempting to re-agitate the issues.
So UPSC is probably the primary contesting party here. Yes. Andaman administration has something to say regarding that vacancies.
Vacancies.
So we'll come to you on that. Let us hear the main point from Mr. Sevan.
Where the petitioner-
Mr. Singh, Mr. Kumar, you please
Fine,
take your
fine.
seats. Yes.
Thank you.
If you have seats behind you, check first.
This is fine. Thank you.
Yes.
But the petitioners are re-agitating the issues which has already been settled and seeking retrospective regularization. My lord, which is impermissible. The issue is also barred by res judicata. The claim of the petitioner for regularization was directly and substantially an issue in OA number 149 of 2001 and stood finally decided by the tribunal in 2004 and affirmed by the Honorable Supreme Court in 2012. As such, the tribunal has rightly held that the applicant cannot reopen the same issue by filing a fresh OA. The settled law that the constructive res judicata applies to the service matter and subsequent litigations are same cause is barred, my lord. The entire case of petitioners is based on the order of 2004, wherein the tribunal has directed that the regularization only to the extent of vacancies in 1997. The expression of left out vacancies or vacancies occurring subsequent must be read harmoniously with the Recruitment Rule 1997, my lord. It refers to vacancies to be filled by regular recruitment process, not by regularization. And regularization can be only be made to the limited vacancies available. RR does not permit regularization, hence retrospective appointment cannot be done, my lord. No antedating of service can be done. As per record, the vacancies are as on 97, my lord, 12 unreserved and 3 STs candidates, total 15 candidates. UPSC has rightly recommended, and therefore there is no legal right accrued to the petitioners for claiming regularization, my lord.
One question to you, Mr. Seval, and
My
one
lord.
question was raised by Mr. Vinnu Kumar. That you justify your because you were directed to recommend. So you resorted to the merit list, this method.
My lord.
So why merit list, not seniority or something else? You can just justify that also. Because you are not an authority who is supposed to, you are to recommend,
My
definitely.
lord, my lord.
But you are not the appointing authority, you are not to check their credentials afresh or prepare a merit list afresh or assess their capabilities. We can understand your difficulty because there are 12 vacancies
My lord.
and you are saddled with 15 people. You have to resort to some method. So why merit list? Because there could not be any reassessment of the merits. They were already tested when they were taken. So why not seniority or something which is already on record? That
Lord,
is one of the questions raised by Mr. Vinnu Kumar and
Lord.
Mr. Singh also by incorporation.
My reply is that, my lord, they have appeared in the interview and accepting the thereafter they now once they are became
So they
unsuccessful,
participated in that-
participated in it.
Participated.
Once they have been unsuccessful, they cannot challenge the
All right.
process, my lord. Petitioner also accepted the fresh appointment, my lord. As such, they are stopped from challenging it after being unsuccessful, my lord. There is no right for retrospective regularization, my lord. Appointment takes effect from the date of actual appointment. The petitions were duly considered, assessed by the selection committee.
You're reading for written notes?
My lord, my lord,
Yes. So
There
you
was
have to put
no-
that on paper and just file it.
my lord, I shall file it. I shall file it. Their non-selection was due to merit position, my lord, hence no arbitration, no discrimination.
So, did you understand you correctly if you say that your argument is that the order which was affirmed up to the Supreme Court, rather you considered before the Supreme Court,
Yeah.
was restricted to their appointment on the vacancy position as it stood on 1997, that cutoff date.
My lord,
Now, they are barred by Estoppel because they have taken subsequent appointments, and this regulation concept comes only from the date of appointment.
my,
So that direction of this, which was affirmed up to the Supreme Court, was restricted to their being given appointments. Since they have taken subsequent appointments, they are now stopped from claiming regularization on the basis of that earlier
my
date.
lord.
So
Yes, sir.
the tribunal order which was affirmed up to the Supreme Court, that did not visualize regularization.
My lord.
That spoke about appointment,
My
and
lord.
they have taken subsequent appointment, so they cannot raise these questions afresh.
My lord,
That is your.
oblige, my lord.
Good.
And in service matter, my lord, there is limited scope for review, my lord. The tribunal order is reasoned and legally sound, my lord. As such, I pray that the petition may be dismissed, my lord.
And the petitioner, as in duty bound, shall ever pray.
My lord.
Yes, Mr.
Yes,
Sevan,
Lord.
we will consider your prayer.
Subsequently,
Mr. Sevan, there is a question.
Kindly come to that letter dated 18th of February 2013. Do you have that? Because I've taken out that miscellaneous taken out by Koshin Parveen. Kindly come to page 76, sir. So this was a letter addressed to the UPSC Deputy Secretary by the Deputy Secretary Health. Did you
Page 76 of Kaushal Parveen.
have you acted in compliance of this, sir? Because there
Yes, sir.
it has been mentioned in this penultimate paragraph. Kindly come to the last
My lord,
at the bottom. Yes.
There is
15th general
yes.
category. Did you get it, sir?
there is a sadistic pleasure in
Yes,
seeing also supplying to the
general category.
different petitions.
180 of.
So we had the same problem. We like it, that we are also having the same problem.
I have,
With him.
I have it. my-
Yes, you have got that.
No, no,
Now,
it's okay.
what was the step taken in respect of this 18th February? Then 18th February, this,
My lord,
Yes.
because there it has been indicated following 15 general category. Because Mr. Singh was saying that earlier there was 12. Then out of 12, 9 goes, then 3 remains. So there is a discrepancy with, because when they were said to be, kindly come to that last line, that
Yes.
there were 15 general categories.
No, no, there were total 15 vacancies. Out of 15, 12 were general and 4 were
Yes,
Lord.
3
yes.
yes,
Total vacancies. were 16.
3 ST. So,
No, 3 ST were appointed. Total vacancies of ST was 4.
But the reasons have been given.
but that you have to clarify in that law notes, because we are also.
No, in this letter it said they have.
Total is 15.
This is why I asked for the numerals actually.
This is
I'll
because,
Because on the 11th of June 1997, they were having total 15 vacancies. Out of 15 vacancies, 12 were
General.
general category and 4 were ST category. Total vacancies were 16.
They say 15.
15 they said because 18 candidates were there. Total in the.
no,
original-
sir, it says that 15 general category.
The 76 last line says 15 general categories. That is what we, why.
It is a
Menon-
mistake, my lord.
Secretary
It is 15 total number of vacancies 15. After 15,
It's 3 ST.
after 15, 3 SC, 12 general.
Oh,
Yes, sir.
12 general.
Can you see the next page, my
In
lord?
the last sentence, is that
Can
erroneous?
you see the next page? My lord, next page, last paragraph, my lord. 12 general. The last,
I just looked it up.
the last paragraph, last 12 general categories. And 3 ST categories.
so that's a typographical error, sir?
My lord, that is a, then some comma is missing. Ah. Total is 15, my lord.
So there were 15 vacancies, out
Hello.
of which 12 were general
General,
and 3 were ST according to the
Nice.
administration.
my lord.
That is the position on which we
Yes,
are
yes,
proceeding from the
Right.
inception.
That is okay. Because that has been clarified because they say 16 because 3 years automatically there is a stopgap arrangement that vacancy automatically goes.
Yes.
So that's why it is indicated, but
But-
3 are no longer in service.
This is that not on, he's not going on the basis of the stopgap. He's saying that already appointed on ad hoc basis.
No, stopgap, these people were stopgap
So
basis.
as they have been said, the 3 vacancies no longer in existence because that has stopgap, it automatically vanishes.
Those are other,
That-
other.
that-
vacancies.
the other way.
So
so the-
you should not
the-
confuse those.
Yes. The resultant.
So that 18, that's the justification of that 18. 18 included this
3
15
automatic
plus
goes-
3 stopgap, which
Yes.
automatic.
Actually, total 18 candidates had gone before the tribunal by
But that-
filing OA number 149.
Right.
2001. Out of 18, 3 candidates had left.
Hmm.
So 15 general candidates were left out. Or by assessing the vacancies on 11/6/1997, they
Yes.
said we have got 12 vacancies for the general category
And 3
4
first.
vacancies for the ST.
SC, right, 16 out of 16.
4.
4 vacancies for the ST.
Okay.
So what is how does this come to 15 then? 15, 12, 3.
Because they have appointed, they said you appoint 12 general and 3 ST only.
What about the fourth one?
Fourth one, backlog again,
Because then the ST.
Pardon?
backlog vacancy,
Oh, that backlog. That's-
only 1 vacancy. That's why I am doubting the
This
assessment.
All right.
portion has to be clarified in your law
Yeah.
notes. Yes, that is what I'm saying.
Connection 16 ছিল 12 4 আর 4 দিন ধরে এক্সপ্লেনেশন ছোট লিখে লাগে 4 ছিল দিন ছিল ব্যাকলগ দেখে হচ্ছে এই বছর যদি ক্যারেট ফরওয়ার্ড পোস্ট হচ্ছে ক্যারেট ফরওয়ার্ড সুতরাং অ্যাকচুয়ালি এই ডেটে পজিশন ছিল এটা হচ্ছে ক্রিস্টালাইজড পজিশন অ্যাজ পার
এই হচ্ছে Christian।
তিনটে দেরি 15 to 12 3 করে
And
As
they
per
apply also they have stated so. Backlog vacancy, only there to be only 1 backlog vacancy.
Thank you, Mr. Singh. We were getting confused on this 16 and 15. So that was explained by them as backlog vacancy. So, good.
But it is clear the position, Lord, and there's 1/8, the same page, next page. The same-
77.
Yes, ma'am. Lordship is looking into the first page, the second page, last paragraph, Lord. Tabulation has been given.
Yes, after the tabulation.
Tabulation,
Yes, yes.
they explain the position. And my Lord, we see the third paragraph. In view of the above, considering long service extended by the ad hoc doctors in Andaman Nicobar, where the regular doctor hesitated to work here to be remote, UPSC may implement the CAT survey convening the selection process.
Yes, that we have seen, Mr.
Yes.
Kumar. We are getting confused with the previous page.
Yes.
The previous page is 15 general and 3. That was apparently an error.
Yes.
Previous page
thereafter-
was an error.
12 plus 15 and 3 was in the subsequent recruitment rule because the 3 are not to be accommodated in the prior vacancies.
All right. All right.
Not the,
That's why the chart is given.
yes. Not the,
So UPSC, if UPSC has finished, then we can hear you now. And you will you will primarily explain the vacancy position.
But the only contention was the letter was never communicated to me, so we are not got
That
any
limitation
objection
doesn't.
challenge it. So not I come to that part. If you
But
are-
at the tribunal held that there are limitation.
It's because not if any grievances arises in terms of the Tribunals Act under.
They did not know.
19.
They said communication was made to UPSC. So how?
No, that's how I'm coming. No, they have participated in selection process. They have given a letter by the UPSC in 2014.
That Estoppel ground is there, participation in
Even the limitation also, my lord.
Ah. Oh, in 2014.
Yes, sir. Where they have,
Yes, yes, these were filed much later.
where they have been given notices by the UPSCs to participate in the selection process. They have duly participated. A final list was published where their names are not appeared.
You can give a short list of date in your.
Yes, yes, I give it.
So you will be in the best position to give that list of date.
Yes. By indicating the page number, I give it the.
That will be better still. And the just list of dates because you are taking the ground of Estoppel and their knowledge also.
Not the,
Yes.
Sapila one
That
is.
they cannot come up for the assessment of the vacancy at a belated stage.
Yes, that is the tribunal has all along the tribunal's view, yes. Because
With their knowledge, they are participating.
Within the knowledge plus participate.
Participate. not all along, Millard, the settled position is in terms of the tribunal's order, the para 16, 17 and 18. The tribunal has said that those who are successful, you give an appointment. Those who are not, let them be
With the vacancy position of that date.
as the vacancy was prior to 1997. Not the moment those who are not successful or those who have not been regularized, they will be allowed to continue at an ad hoc basis.
Yes.
But the department as well as the administration want the 3 doctors also to be
You want
considered.
one step
So
further.
we have said one step further that the 1997, 3 of them may be considered on the vacancies which is arose in 1997. But subsequently, when the vacancy was filled up in 2016, they have been called for that their willingness was sought. Whether you are willing to participate in the selection process.
For these 3 left out people were given appointment.
Yes, they have participated. They given their willingness. As I pointing out in yesterday lordship that they have given the willingness, saying that yes, we are ready to participate in some selection process. After acceptance of the willingness, the selection process was taken place and they have been appointed in 2016. Once when they appointed in 2016, they are now relegating back to the cause of issues which is done in 2013, 14, saying that no, as we are also come under the purview, the merit list has to be taken into consideration. But that cannot be done at a belated stage. Altogether, there are 12 persons have been appointed. And if at all anything is changes, then the 12 persons also to be
So
affected.
that
and they have to
goes,
be made
it's
as a
a fresh selection process.
Yes, my lord. 2016, they have been, the UPSC has given asking their willingness. If they are not tendered, then the issues are different. They accepted that now we are ready to be considered in 2016.
হয়ে যাওয়ার পর 3 দিন বাদ চলে গেল তাদের অ্যাডপশন কন্টিনিউ করেছে চেষ্টা করছে they attempted to subsequently consider the subsequent vacancy position and also incorporate but that was probably contrary to the tribunal therefore they were given the opportunity to participate in fresh interviews which they did they were selected they have taken the job their work so therefore they cannot revert back and challenge that yes relegate back and say give me appointment that was restricted to giving appointment therefore seniority the tribunal did not say seniority giving also সেটা বিশ্বাস বলেন এখন যে retrospectively seniority দেওয়া যায় না particularly active participant
That's not the, because the Supreme Court has, we have admitted the position of tribunal's order. So one.
That is the last
That
question.
is the last.
Point.
And they have been found, not, they say that we are not having any knowledge. In 13, the communication may not be accepted that it is internal communication between the UPSC and the administration. But 2014, when a notice was issued to you to participate in the process, you participated. And a final merit list was published in 2014. You know that you have not been selected. Rather, you know that your names have not appeared in the merit list, or rather the selected list prepared by the UPSC. You could have been educated at that time. What is the modus operandi adopted by the UPSC, whether selection
They took the subsequent job and subsequently when the question, they became aware of the fact that they had missed out on the regulation and the eligibility. So therefore, they have now preferred to
Not
challenge.
preferred this.
That is your.
This is my submission. My submission is whether the tribunal has rightly held, because the issues with regard to regulation was already settled in by the earlier round of litigation by the tribunal, which was affirmed later by the Supreme Court.
No,
That cannot be reopened. And based on that, the vacancy position was notified. And based on that vacancy position, the persons who have been found to be successful, because
Yes.
there is a rider in the tribunal's order, those who become successful, they have to be regularized. So
That issue cannot be culminated in the. Yes.
that is why they are agitating. That's why the tribunal has said it is, you cannot agitate the issues which has already been decided by us on earlier round of litigation. So the writ petition was, the original application was dismissed.
So
And the point of limitation was said that you cannot agitate that after this long.
very short reply, Mr. Elsa.
It was not affirmed by the Supreme. Because the Supreme Court.
But they,
We are
that
good.
is the last position. Mr. Singh, that is the last position. That was not further challenge.
Now,
Supreme Court, you also considered to their concession. So it was
they
not
are-
reopened for them.
They have assistance. And in terms of the vacancy assets, they have regularized 12 people, you are candidates.
Yes,
And
yes.
3 STs. I was not paid. Now.
But you accepted that and you to participated in the subsequent process.
I participated because I am an untried youth, I will thrown out.
You did not challenge at that point of time, you could have challenged.
No.
Instead of participation there, you could have challenged that I should not have been left out.
And-
You participated, you are doing a job, and then when the question of this regulation and previous benefits are concerned, you take up a challenge by these ways. That is their point.
No, what has happened? They say, filing of the case commitment.
Tell us.
First, they say that I have given a willingness in 2006. And then in 2013,
Yes.
they have shown that, I am willing to participate in revenue selection process
Yes.
for 4 general candidates. This is at 113 page.
Hmm.
Now the question is, I have participated with the hope and expectations that I will be recognized from that date.
That is whether that is legitimate or illegitimate, that will consider.
Because we don't know whether the vacancy is not there. I was not knowing what is the vacancy position.
The tribunal order did not say that you have to, it did not go further by saying that as per the vacancy position and subject to confirmation, it said the appointment has to be given. It stopped there. And those who did not get appointment will carry on and stop there. That it stopped there. It
They will
did not
continue on
say-
that. Still the see normally.
Right. Now that it stopped there, it did not say that the unsuccessful candidates, they will also be getting the benefit of regularization by deeming them to have been appointed.
Because.
You wait during that period.
No,
check on
the
your-
question is, in 6, not only I have given my willingness, all the 18 candidates have given their willingness.
Yes, we are
All 18.
concerned with the 3 people who are before us.
We have given the
You have
willingness.
given your
Participate
consent
in
and
selection
participated,
process.
and you didn't challenge the previous.
No, but I don't know what is the vacancy position. Vacancy position, I have come to know after my representation has been rejected.
Now, that you took the point. Yes.
I have moved the tribunal passed an order that you dispose of his representation by reason and speaking order, which I have shown to your lordship.
Yes.
Once that was passed, I came to know what is the vacancy position. Therefore, I collected all these documents,
Mr. Singh, you have argued.
and I filed immediately the order.
Yeah, go and say. Yes, Mr. Kumar.
Well, only 3 things, my lord.
Nutshell.
First
Yes.
of all, my lord, this joining was without prejudice, 202 page number.
That you pointed out.
Yes. Secondly, my lord, the challenge which my learned friend says is barred by delay and all. My lord, the order of appointment was passed in 24th of December 2014. We filed the original, I filed the representation on 6th of September. My lord, in terms of the Tribunal Act, my lord, section 21.
6th of September, which year?
2016, my lord.
So
2016.
later.
My lord, the tribunal under section 21 enjoys the power even in the cases where, because the time period is 1 year. Within 1 year, a person can agitate his grievances. If it is delayed on section 21, come to the aid, and if the tribunal consider that it is the ground which has been stated are genuine ground, tribunal will condone the delay and the OA will taken into
Akin to
account.
section 5.
So yes, my lord. Therefore, my lord, this point they cannot take today because that is not the case, because the OA was admitted. Once it is admitted under section 19 of the Tribunal Act, my lord, thereafter it is adjudicated on merit. So this point is no more, they can take this point. And only one thing, my lord. Only my case, entire case revolved around what would be the modality, what is the power, or what is the role of UPSC? Because, my lord, the recruitment rule says the proceeding of the DPC relating to confirmation. Only the role of the UPSC is pertaining to confirmation shall be sent to the UPSC. So the appointment, though it was about this ought to be on regular basis, ought to be on regular basis, confirmation will not be made. Under service jurisprudence, there are two types of confirmation. One, in the order itself, it will be stated that within yes, it will be probation. In some authority, there is a confirmation. Here, since it is specifically stated that confirmation has to be on the basis of the UPSC, therefore the UPSC is confined to confirmation. It's were made at different point of time. So the modality would have been up because, my lord, I was appointed in 89, some appointed in 81, some appointed in 83. We are not part of the same DPC.
No.
Under such circumstances, whether the modality of taking into consideration seniority is legal and, my lord, whether it is arbitrary. This is the only issue, my lord. One.
Oral arguments are concluded. First up, learned counsel for the respective parties are requested to file their written notes of arguments on April 20, 2026, when the matter shall next be listed under the heading to be mentioned for such limited purpose. We put it on Monday in the list and just nutshell arguments and Mr. Kumar and Mr. Singh, please. Mr. Rakesh Kumar, you try to confine to that vacancy position and Mr. So there has to be a coordination between you two also. As you argued today.
Yes, sir.
Put that in a written.
Obliged.
Thanks. We are extremely sorry for cutting you short, both of you. We could have heard more, but since this circuit benches, this is the issue. I mean, we have to finish it fast. Otherwise, thank you so much, Mr. The list. Night idea order sheet. Sure. Yes.
Make these your lordships.
Yes, Mr. Chand.
The last order your lordship will first see. April 13, 2026, passed by your lordships. What was the submission of the private respondent and then what fell from your lordship?
Yes. Yes, both questions have to be answered by you. There are two questions.
Now, my lord, before I start,
Yes, Mr. Chand.
two simple propositions, my lord. One is, an court should prejudice no one.
Yes.
Well settled principle. And the second one, where there is a right, there is a remedy. These are the two basic principles, my lord. Now, my lord, maintainability is a mixed question of law and fact.
Yes.
Now, lordship kindly comes to the stay application, can one.
Yes. Yes, Mr. Chand, to which page?
Can one, my lord.
Which page?
My lord. It's 3 paragraph 4 below. Or rather paragraph 3 first.
Yes.
What was the prayers in the petition? Money there. Better.
You have seen it, Mr. Shyam. What is your argument?
Now, Lord, the OP number 1 is not affected in any way by this. He is a mere busybody, not having any cause of action which will affect him because of my construction or anything. Therefore, it would be a writ petition.
Sir, if you don't mind, can you come this side?
Sorry.
He was a complainant.
He
He was a complainant before the authorities.
happens, it should not shoot us. What I want to say first is
Yes.
that he, in his personal capacity, could not have any cause of action. If at all it was a cause of action, it would be a PIL. If at all. If it is a PIL, then the Honorable Single Bench has no jurisdiction. This is one aim of my submission, Lord.
Yes. So therefore, it should have been rejected at the outset.
This
Having not
one
done
aim.
directing affidavits.
There are many.
This is one name.
Yes.
Yes. What is the next thing?
Kindly comes to paragraph 4.
We have read it, Mr. Shant. You can make your arguments.
Now,
We want to go fast. Yes.
what is the order? It's 51, Lord.
Name of the words. Yes.
Page 51, Lord. No reflection, not served. How do we get that it was not served? Lord, should we look at page 52. When should be served?
Yes.
Order is passed when the 17.
Who is appealing for the other side, Mr. Shant?
Mr. Kumar is there on behalf of the official assets and my learned friend.
Right.
So, Lord, the petition is being served after the passing of the order. It was passed on 17th.
Yes.
Now kindly comes to paragraph 7. Page 4, paragraph 7.
Yes.
And page 5, Roman numeral is very important. I don't want to place it, your lordship will read it. Down that lordship, I'm sorry.
Yes.
Now, section E6 is at page 110.
Yes.
Yes, sir.
My lord is reading, that is what.
Next paragraph.
Yeah. Now, therefore, an earlier action on the same cause of action was filed through a special power of attorney, which itself did not authorize the person concerned to file the petition. And that in the same way for the first time. Then, now kindly comes to page 112, Umar. Hundred and 12 and 13.
Yes, 12 and 13.
Dates are relevant, February 16 and February 24. Petitions. I could not come. The matter was, adjournment was taken so that the which was passed of it was set aside by the judicial bench. In the other part, seal of my continued. Matter was pending. So the inquiry I not secret and adjournments were taken on February 16th and February 24th. Now, Lord, kindly comes to page 6, paragraph Roman 3.
Yes.
A, the relevant for A is page 30. Lord, you can look at page 30. When is the complaint being made? On 11th. 11 to just before that, we have come to know that order will continue because earlier petition would go. Because the power of attorney was not that proper power of attorney. Now, when we have, when the petition was filed, petition was 16th the petition was filed.
District petition.
Yes. Where will get document number 27?
Yes.
It was filed on 16 and next page. That order affidavit direction. It's okay. But you have to conduct. Then we have what you kindly comes to paragraph 10.
Yes. Mr. Shamathu, wasn't it a different person who filed the previous writ petition?
Yes.
So why do you say res judicata is applicable? The point of locus standi, yes. Similar principle.
Those are there. You know, what I'm trying to say, just like lifting the veil.
What is
Here,
the nexus between them?
the learned advocate,
Oh, through the advocate?
Lordship will see. Ultimately, who is the person who is filing the writ petition or moving the petition? Taking acts.
Are you sorry? By power, are you referring to the vakalatnama? Or power of attorney was given?
One, a power of attorney was given.
That was a power of attorney.
That was a special power of attorney by a petition to someone, and it was used for the having any because it was not related to the filing of a fresh writ petition, but earlier writ petition. Then
Basically.
then that writ petition fails, or the amount fail, adjournments are taken so that the intent continues until another surreptitious without that act.
But here no interim order was passed.
No, ultimately it saddens me with the difficulty.
What is that even?
Difficulty is, I'll have to again contest a matter which I have recently won on the same kind of action.
Just how you can take all these points before the.
No.
This point. What is this a judgment under?
I'll come to that. I'll come to that. Now, relating to judgment, clause 15, no one has defined judgment, right? Now,
Wherever your rights are affected, some rights have to be affected.
no, it's not that. Question is not that you will.
Locus standi point.
Therefore, it cannot. Had I been served a copy of the petition,
Even now you can do even directed to file affidavits. So you can appear on the next date and file your affidavit.
I will find appreciate what I'm trying to say. Your Lordship will take a simple view of the matter because of the facts. Had it been the facts are different, facts are simple, no problem. It is a first writ petition, etc.
No, we completely understand what you're saying, Mr. Sharma.
Yes.
So you say there was malafides, first of all, there was this surreptitious act of rather, you are not going to the extent of saying it's a fraud upon the court, but something akin to that.
I can't say all those things because my knowledge is there. That is why I have not made it. So submissions are allowed. I have said your Lordship.
Appreciate.
Now, Lord.
Nature of the allegations is there.
Now, Lord.
So you go before that court and point out.
No. Lordship will appreciate because I have brought to it. First of all, one is in a there is no definition that is settled. Now, the first judgment which was there, Shah Babulal Khilji versus Jayavan B.
Yes.
Kanya on interlocutory orders. I'll just take one line. I'll show your Lordship just one line. Lordship straightaway comes to the last page, page 70.
Yes.
The last few lines, in my opinion, 7 or 10. This is a
Yes. After the quotation mark.
yes. In my opinion, sir, in my opinion, an exhaustive or comprehensive definition of judgment as contemplated in of the letters patent cannot be properly given. And it will be wise to remember that in letters patent appeal itself, there is no definition of the word judgment. The expression has necessarily to be construed and interpreted in each particular case.
So you are on the jurisdiction, court jurisdiction.
Yes, my lord. This is one.
Affects the court jurisdiction.
My lord,
Affects the court's jurisdiction.
affect the court's judgment. I'm grateful, my lord.
Yes.
Another judgment, recent one. I wouldn't, I'm sorry, my lord, to trouble your lordship. I wouldn't have taken this trouble. I would have bowed down to your lordships. But because of the special circumstances, my lord, I have to address your lordship. Your lordship kindly come straight away
Yes.
to page 15,
Page 15, yes.
paragraph 31.
13, yes.
It is argued before us that the writ appeals filed by the Court of India are not maintainable under clause 15 of the letters patent, as it was not a judgment since the learned single judge had not decided any rights between the parties. This is a division bench order. We are unable to agree with this argument. Even if the learned single judge has observed that the petitioner could still act upon the added subclause to clause 5, and if it could be lawfully done. One thing is certain, that the learned single judge has passed an injunction against the appellant Polinga for restraining it from incorporating the same in the contract document. Therefore, it cannot be said that no rights are decided upon in the order does not amount to a judgment. We reject your argument regarding the penalty of the issue of propriety of the entertained was not argued before the I'm sorry. We reject the argument regarding penalty of the appeals. It was then submitted that the question regarding the penalty, the issue of propriety of it being entertained was not argued before the learned single judge, and therefore it should not be considered by us. We fail to follow any such argument. We have already shown that the writ petition should not have been entertained as it involved disputed questions of fact, etc. My point is different. Under such circumstances, the entertainment of the writ petitions becomes a question of jurisdiction. Now, Lord, there is a recent judgment of the Kerala High Court, Lord, a division bench.
Yes, Mr. Sharma.
Lord, Lordship comes to the last page, Lord, page 32. I'm showing just because I wanted to. I'm sorry that
fully appreciate that, Mr.
paragraph 72, Lord.
Said.
View of the aforesaid, we find that an intra-court appeal is maintainable under Section 5 of the Kerala High Court Act against an ex parte and ad interim order or any order which has clearly affected the right of a party to pursue its statutory remedy.
This is not applicable.
The nature of the order gives rise to the reference conforms to the standards. You know, I mean to say, Lord, that ex parte ad interim order, ultimately, Lord, ex parte the order is there.
That was a converse situation. There it had affected the right of a party to pursue its statutory remedy.
That's right, Lord.
Protection was granted.
What I mean to say, Lord, whether an injunction is granted or not, Lord, ultimately, if I am thrust to a litigation unnecessarily, that to ex parte, whether your lordships will consider that. My only submission is that ex parte, if I had participated, then probably
You have to thrust yourself into this appeal.
my lord.
In any event, you had to thrust yourself into this appeal. So either way.
Now, last time,
Come here.
last time the same thing happened. I had Yes, I have to
Appeared there and asked for costs, exemplary costs.
I had, but because the special that was without that's why we can ask now. I'm showing that now. I'm showing that. Now I'm not judgment, which I am feeling I should show your lordship, is a division bench order. Not only the principle, the analogy that I'm relying upon. Lordship's reading comes to page 9, paragraph 47.
Yes, Mr.
Paragraph 47 is contempt, Lordship looks at paragraph 49.
All right.
Paragraph 48 and then 49. Excellent.
Now, circumvent the pending court proceedings, rushes to overreach the court.
So rushes to overreach the court and very well.
Now, look, there is a can too. There are very many other judgments. I don't think I should cite it because Lord Lordship will take up can too.
Yes. Can you? Yes.
Because a submission was made that order, we have challenged it, subsequently another order has been passed
In fact,
and we have, there's been infractions. Now, that is why can too, well, I'm showing the Lordship. Lordship kindly comes to the subsequent order is at page 14,
no, you were respondent number what in the appeal in the writ petition?
3.
So you appeared on that date.
I appear, but Lordship will look at that order. Who has paid for extension? Paragraph 2. My learned junior appeared on that day because I couldn't, because of the connectivity problem sometimes there. 3 digits for this thing, affidavit. He stated that is not there on record. He only stated that we have already filed an appeal. The appeal is coming up. But we thinking that nothing has been done.
But you did not take this point at all. Should have instructed your learned junior to take this point. At least the rudiments of the point should have been argued on this date.
He said this, that appeal has been preferred. He is asking for extension of time. And
We cannot go
paragraph 5.
submission from the bar, Mr.
Further opportunity to the respondent. 3.
Yes.
Now the question is now similarly, similar situation, whether the petition for this on that should kindly comes to that. Page 14. Sorry,
Oh, so 14 is the.
I'm sorry. 15.
Yes.
Basically, Lordship reads it, it will be easier for you, faster for your Lordship.
This is in connection with what?
earlier petition which was ultimately.
This is in correction, a different appeal or this appeal?
Earlier appeal in the first writ petition which was filed. Relevant 17 dot. Middle of the page. We have heard the learned advocates. Lordship has got it.
Yes.
I am praying for the same problem. I am praying that Lordship will hold the same proposition. Give me the affidavit of service. Return I have. And Lord, what is in the cost tracking? The name, address that we had sent the speed post, and this is what is the result. Next page, and next slide.
Insufficient address. Yes.
What defines?
Okay.
Yes, Mr. Shaman.
One more thing only, just to sum up, look, one is look that page 7, paragraph 10, where lifting the veil I had prayed for,
Yes.
as to how it is being filed.
But Mr. Shamant, isn't your this lifting bill argument contradicted in the sense that the previous writ petition was filed by a person who had a special power of attorney, not relating to that matter?
Not on that ground, Miller.
No, but if that be so, then whether he's moving the application or his acts can bind the principal.
Not that.
You are giving registered through the agent.
Who the agent? Because the person who is moving the court, it is a gross abuse of the process of court and process of law.
You and I, Mr. Samanta, may appoint the same power of attorney, the same constituted attorney. That does not mean that my judgment will be res judicata on you.
But perhaps I have not been able to
Clearly
explain.
having the same
Not
power
on
of
that,
attorney,
Lord, I am not on that.
then how does res judicata come in? There are two different.
Lifting the veil from the responsible person behind silent petition. You kindly appreciate what you submit.
Who is the ostensible party? The agent you are saying is the ostensible party.
The learned advocate.
No, but you cannot say. And no, we are not touchy or because it's a learned advocate. If a learned advocate or a judge does a wrong, equal wrong. We are not touchy on that. But we are here, it's not a question of we are being touchy or sensitive on this because he's a learned advocate. But Mr. Shamant, on principle of law, so just we are wanting to learn from you. So this, suppose I appoint X as a power of attorney holder. Justice Dasde appoints X himself as a power of attorney holder in a different matter. So my writ petition, some decision is passed. Suppose on merits even. Subsequent writ petition by Dasde to the same
Milord, it's
holder.
not that, Milord. I'm sorry. Again, I'm
Is the
that.
agent
It
should not be architect.
Milord,
You are input.
I'm sorry, I'm trying to explain again.
Yes,
Lord, a wakala claim is also the nature of a power of attorney.
absolutely.
If it is so, then a person entrusts a person to be plead before the court. Another person entrusts the same person to plead before the court. But if it is the other way around, the person who comes before the court is the same person who is using
We then we will have to resort to two levels of conjecture. First of all, that he is not the agent, but the principal architect. That is absolutely in the domain of conjecture unless the facts come before the court.
Facts are there. What facts your lordship require? Your lordship tells me I will give you lordship the facts.
Court cannot, because we cannot expand the scope of the appeal, Mr. Shamut. All these are arguable before the learned single judge. Learned,
Ranjit Halder considers that. Kindly considers that. Because the analogy, I have not said anything about the matter, contempt, etc. What I have said is how the petition is etc. If that doesn't speak volumes, then Lord, I have nothing further to say. Your lordship will have to consider that aspect of the matter. This is not a simple case, as I say, I would not come personally to my lord in such a small matter because of the fact that a person is being helped and being given proceedings thrust upon him because of such conduct. That your lordship will have to consider sitting or the appeal. Your lordship are sitting in the judgment seat of Recruitment. Your lordship has to consider that aspect. Your lordship cannot wish it away. No.
I'd like to assume the other part of Vikram. That is much more lucrative too. Going out in the night in some other dress and living life. That appeals to me much more than sitting on the throne.
Very simple,
I
man.
speak for myself. I don't know about Justice. She must also have the same feeling. Rather than enthroning ourselves. So we can appreciate that, but Mr. Shamanto, we are a bit still hesitant here. Because not because of any other thing, only because of the fact that this, if you enter into the merits of your allegations and but many
No, your lordship need
we're usurping the judicial, the writ code.
PIL, whether it is maintainable. There is no it's a PIL. It's not his personal.
It's not couched as a PIL, it's couched as an ordinary writ petition. Can we reject, we can reject a writ petition, a single judge can reject a writ petition, saying that you don't have any locus standi. But we cannot convert the
petition passed and the same. And affirm. That is there. Where is that judgment? That is also there. Principle. Bench which has passed that order. I think I can show you what should probably it's here. Or I'll give you. But one thing that you will kindly consider, subject to what falls from my lord. Lordship will keep my argument, think, pass the order. It's not that your lordship has to pass it today.
we will not reserve judgment on this because we have to think after hearing you.
Naturally.
Yeah.
Because I have learned it that
These are very
if I sleep over a matter, sometimes the points settle down.
true. These are knee-jerk
And
action.
not every day.
Responses from you. We have not opined finally anything.
That's it. That's it.
And heard the others.
That's true. But not the time to my learned friend his client that address. My affidavit of service is there, but he has
No, we'll reserve it on I mean, If we hold that the appeal is not maintainable, we'll dismiss it.
Yes,
Otherwise, if we entertain it, then we'll think about passing ad interim order also, because the
yes,
similar order as Justice Tapaputra Chakraborty is being
yes,
passed.
yes.
So,
And another decision which I asked my learned junior to give it to your lordship's court officers, blood.
so the crux of your submission is regarding res judicata, relying on piercing the veil concept. In the sense that you say the same advocate was the architect for both. And locus standi is a question of jurisdiction, therefore it pertains to clause 15 also. As held by several judgments, jurisdiction question pertains to. So it should not have been entertained, should have been rejected at the threshold.
And you know, it's party. I was not sure why it should happen. Why that should happen, your lordship will have to also consider. In fact, you know, if your lordship forgets my other arguments, ex parte itself is sufficient cause for your lordships to interfere.
One impediment in your, in your way will be the second order where you have not taken this point. Because we cannot rely on we can rely on you as advocates, both of you. You and your learned junior equally. But we cannot take submissions from the bar if it's not recorded in the order that this objection was taken by.
If he files an affidavit saying that
Before whom, Mr. Shamanta, you tell us?
I know single bench it has to
What's
go.
the law?
That's the problem.
What
I know
transpired in court on that day?
That's right.
For the same
That's
judge.
lordship will,
That's why we were wondering whether you should go before the learned singer. Same
No.
judge will not be there.
no, that's right, but you know that. But lordship will consider one thing, but the way it is, because respondent number 3 has no learned advocate, my learned junior, he is the respondent number 3.
He was not the respondent.
Yes, he did not make submission that extend the time. That by implication means, Lord, that he had made that submission. Sometimes, Lord, implication has an effect. Your lordship will kindly consider that. Those are my humble submissions. I'm sorry to trouble your lordship for so long.
And this you don't have any affidavit of service, Mr.
That is with the affidavit of service, Lord. That is with the affidavit of service. That should have,
This is on the writ petitioner.
yes, writ petition.
Mr. President, writ petitioner.
Yes,
Very well. So we'll take this on record, and since you are appearing, so
I am not issued the CAN application.
That is what he will say. That is what he will say.
obviously he'll
Okay.
say.
You have not served upon me.
No, but
Send him to speed post. I am appealing all through.
he did not accept.
Appeal, how can?
Hello?
In the appeal.
No. Appeal
You should file an affidavit of service.
But affidavit of service, I have given.
What's it?
Fine. Thereafter, I pointed out before the honorable single judge, directed for affidavit. Thereafter, he filed CAN 2 by speed post. Why speed post?
Because he is not accepting by hand. My learned.
Sir, don't make submission. False submission.
All right. Let us hear, Mr. President.
Yes.
Well,
Yes.
big petition is very well maintainable. Kindly come to, he is an encroacher. Encroacher of government property worth 10 crore.
This one.
Kindly come to page 28. There are
Can one, obviously.
of the appeal copy, my lord, I received this one bunch. Page 28. Your lordship will find it. Press note.
To 28 years,
Press note is there, my lord.
right?
Series of press note was published by the administration. Asking the citizens lodge a complaint for encroachers. This one, my lord.
Yes, we've got it.
So therefore, no question of locus standing. It is very well maintainable. Anybody can lodge complaint. Well, I am reading the last portion of the press note.
You are respondent number 1 here in this appeal.
Yes,
Yes, last portion.
last second paragraph. Let the district administration has urged the citizens to lodge
Report illegal.
illegal construction or any encroachment to the district administration. District complaint. Anybody can lodge complaint. Why he is leveling allegation against the advocate, I fail to understand. He is also appearing. Same matter. This is first point. My second point is that
Well, this matter was listed earlier on 11th March. He did not raise any point of maintainability. In appeal court, he is precluded from raising any point of maintainability. Thereafter, matter was fixed again on 13th April before the honorable single judge. In 13th April also, he has not raised the point.
I've
of
got a copy of the 13th April order. Even if you have a server copy, we'll.
Well,
take that.
I'm very sorry, my lord. What is there? I sort order.
What sort of a copy is this? You take out a server copy.
Only, my lord. I'm sorry.
You're too miser, Mr. Prasanth. We accept all the allegations. We accept all the allegations made in the. All the allegations. আপনাদের কথা বলতে পারছে বলে।
I'm sorry. We did not raise this point of maintainability also.
Justice Das, they took this matter on the last question. Thank God.
Yes.
So relieved.
Yes, she took the matter and my
Matter.
petition bench.
No, no.
Single case.
Single way she took the matter. So she's also guilty of the same offense which you are alleging. So they have to release it.
Just. But even then, that doesn't change the complexion of the original order.
We cannot touch the matter now. Physically we have touched, but mentally we cannot touch the matter anymore. 17th of April, that order.
13th April.
You give us a copy, we'll keep it on record.
The actual printing part.
13th.
We'll penalize you 1 rupee. You'll pay 1 rupee to the court officers for this half-page thing. Because you have to keep it on record. Please,
And take out the print.
please, anybody donate to him some money so that he can take out a printout, Mr. Prasanth.
1340.
Affidavit of service as well as an envelope.
Well, that may be given to me, my lord. It was not given to me.
What?
We can do.
Can do will give it just now.
Yes.
It happened last time also.
During the next circuit. Another visit to Andaman. And you have found
Circuit till June.
and you have found a host in your adversary.
No, there is no bench.
কি বললাম? An envelope with the endorsement double inverted insufficient address. Full stop, next para. In any event, comma, since all the respondents are appearing, comma, there is no impediment in taking up the matter. Full stop, next para. However, comma, upon after hearing learned counsel appearing for the appellant, comma, learned counsel appearing for the respondent number 1 during arguments, comma, places reliance on an order dated April 13, 2026, passed in WPA 79 of 2026, comma, a previous order in which is the subject matter of challenge in the present appeal. Full stop, next para. From the tenor of the arguments, comma, it is evident that the maintainability of the writ petition itself is also under challenge in the appeal. Full stop, in any event, comma, since we find at the outset that the order dated April 13, 2026 passed in the writ petition was passed by one of us within bracket Justice Das, full name, comma, for the sake of propriety, comma, we release the matter on personal ground with liberty to the appellant to move the appeal before the next circuit. Full stop,
Because your next circuit is not there till June.
whichever is the next circuit.
No, instead of that, to take appropriate steps before because then I can move it in.
And or to take appropriate steps for assignment of the matter before the honorable Chief Justice. For the next para, the appellant shall also serve a copy of Can 2 of. It is hereby recorded that the appellant, comma, through counsel, comma, has served a copy of Can 2 of 2026 on the respondent number 1 here and now.
Because may I make one humble prayer, since we were,
Justice Dasdev will not take the matter.
by the way, not that, but I think.
No.
But may I take back the judgments, etc., so that, since your lordships have not,
Yes, yes.
I'm sorry to trouble you.
We have taken notes. Very well. The notes may help the other bench which takes up the matter.
Very unfortunate for me that, very unfortunate for me. I wanted a nice judgment of my lordship.
We should have pointed out this, sir. Come on. And in any event, we have prima facie against you. So that will be better for your client.
Blair,
Thank
Blair.
No, but
I still remember in one matter, one of the learned judges, he told me that I will dismiss your matter. I told the learned judge, my lord, kindly gives me opportunity to read whatever lordships recited about the judgments, Justice Bhavavati Banerjee's. He said, it won't come through. I'm dismissing. I said, my lord, kindly don't. He didn't. And the next court, I got a judgment on that.
luck of client.
I'm grateful to that. I'm sorry to trouble you. He should have this point.
You should have.
Frankly speaking,
You should have.
frankly speaking, Lord, since I am in Calcutta, I have some difficulty in coordinating. That is the main problem. Otherwise, we should not have talked that. Anyway, I'm sorry.
Thank. Yes, next. Yes.
Well, I appeal for the petitioner.
I am for the respondent, lords.
It's a criminal appeal against the order of conviction passed by the Learned Additional Session Judge Mayabandar.
So admission for admission.
For admission, there is also an application for bail accompanied with an application for condonation of delay of 62 days.
So condemning the delay as a matter of course. Condemning the delay in the formal order of admission of the appeal, then we'll hear you on the
Yes.
on the other application, the suspension sentence. The appeal is admitted to be heard on the grounds taken in the memorandum of appeal. For some issue, in view of the appearance of the, is there any other respondent who is not appearing? The complainant or anybody? His conviction.
Against the conviction.
Victim has to make a party.
Oh, victim condition, right. Issue usual notices
So case.
on the respondent number 2, for service on the respondent number 1 stroke state is dispensed with in view of the appearance of the state through learned public prosecutor. For your APP or your PPP? Learned, sorry, learned public prosecutor. For next para. আচ্ছা এটার আগে একটা অ্যাড করে দিন in view of sufficient explanation for the delay in filing the appeal having been made out comma can CRM 1 is the convention
Yes,
CRM DB within bracket DB 1 of 2026 is allowed comma thereby condoning the delay in preferring the appeal, then whatever you have said that this appeal will be heard and all we'll add some. To one. Oh, CRAN 1. No, sorry, CRAN 1 means. CRAN 1. Correct. No, yes, please move the bail.
yes. No,
What is the offense?
it's an offense under section 5/6 of POCSO Act, wherein I have been convicted to undergo an imprisonment of 20 years.
What was the age of the victim girl?
Now, the age of the victim girl as on date was 17 years and
On that Trial could records be called for, paper books be prepared. পেন্সিল দিতে তোমার তো উনি ওটা চাইছেন। এটা আমার তো নেই।
Lordships,
Yes,
may I seek my lord's indulgence? My lord,
Yes.
your lordship had fixed the matter today,
yes.
and it's an important matter in which,
Which I think, Mr.
my lord,
Pandey?
it is item number 16, my lords. Your lordship will recollect that this is with regards to regularization of 7,240 employees.
Yes,
So,
on a single.
CV.
Division bench.
lordship, before your lordships, my lords have issued notice in this matter. Your lordship will recollect.
16 is the other side there? No, I am there, Malad. So, because we are in recess, so we'll rise for 10 minutes and come back and resume your matter, please. If all of you are.
Yes, yes, we are here, my lords.
Yes. Mr. Nataraj is also there.
Yes, yes.
People.
My lord, perhaps he is representing the administration,
I'm Andaman
Andaman
administration.
administration.
Good. So we'll.
Lordship.
We are assembling about 10 minutes.
Lordships,
5 minutes to 2. We assemble and take up this matter.
lordships,
Then
deeply grateful.
Later we'll take up the single event. Single events. We'll not take up any other division.
I am
Deeply,
paper book already I have supplied
We'll
to
come with the silent things.
deeply grateful, deeply.
Issue.
அவருக்கு அது முக்கியம் இல்ல இதான் முக்கியம் 7,000 பேர்
বললাম তো তোমার এতক্ষণ ধরে খাওয়ার কি আছে, আমরা তো সেরে নেব। তাড়াতাড়ি ডাক, তাড়াতাড়ি ডাক। দাঁড়ান দাঁড়ান, কাকে ডাকছেন? ওরা আসবে তো। আপনি বসুন, আপনাকে কিচ্ছু করতে হবে না, যা বলছি করে যান। এসো, এতক্ষণ ধরে খাওয়ার কি আছে? আর মনোজ 5-এ অর্ডার হয়েছে কোনো, যেটা সুরজিৎ সামন্ত মুখ করলেন? কি অর্ডার? অর্ডার পাস করেছি তো?
আমারও ভালো।
হ্যাঁ, ওটা তাড়াতাড়ি করে দিও যাতে ম্যাডাম সিঙ্গেল নষ্ট হয়। কল করুক, তুমি নিয়ে নাও ডিকটেশন। হ্যাঁ, কল করুন। Yes, item 16. Let them come online.
This paper was, my lord,
Yes,
copy was served in advance.
right. You're for the appellant?
No, my lord, we are.
You cannot be for the appellant.
Minutes. I am for the appellant, my lords.
Yes, yes, Mr. Chair.
Lordships. May please, your Honor.
Please, 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 yes.
My lords, we have referred letters patent appeal
Yes,
against the impugned judgment passed by Honorable Single Judge.
Hmm.
Dated, my lords, this is at page 32, it starts from page 32, my lords.
32, right.
Lordships.
Have you got a copy of the paper book, Mr. Sanjay?
Your lordships, my lords, the paper book, which actually, my lords, that is all part of the writ petitions, etc., my lords. We have got that.
So, but
But
if
if-
you haven't got a copy of the paper book, they will follow from the writ petition.
Sorry,
If you have not got a copy of the paper book, they will no, so you might not have a copy, then will follow from the writ petition. Acha, do you have a copy of the paper book?
my lords, they have supplied the copy, my lords.
So we can follow from that, the pagination.
But before that, my lords, if your lordship would see the judgment, my lords, from the appeal paper book, my lord, if not inconvenient to my lords, my lord.
Second volume.
All right. Yes, it's at.
But since, my lord, it has got some background, therefore,
No difficulty. We'll look into that. Page
Lord.
352 of the paper.
it's page 32, my lords. Lordship could get it, my lords.
It's 352 in the paper book. Got it. Yes.
Lordships. 352, how come it moved down? Now, if your lordship will see,
Yes.
the writ petitioners assail a letter dated 13th December 2023, issued by the authority by such letter, Department of Personnel and Training refused to grant concurrence to a scheme for regularization formulated by the administration. This decision is under challenge,
Yes.
lordships. So, my lords, what had happened that in view of certain orders of this honorable court, now, my lord, the Andaman Nicobar administration framed a scheme because they had no authority to implement it, because the funds are required. That comes only from the government of India, my lord. My lord, it comes from the finance ministry, my lords. So therefore, as even in the scheme, it was clearly mentioned that it can only become applicable on concurrence by the government of India. So therefore, it was referred to the government of India, and it was not accepted by government of India. So the decision of government of India has been challenged.
Yes.
Now, my lords, further, before coming to the further paragraphs of the order, one background also I may be permitted to kindly explain to lordship, my lords. That
Yes.
is, my lords, that earlier, my lords, a writ petition was filed by the association,
Yes.
seeking wages, my lord, to the daily rated employees up to from 1980 on the basis of 1988 office memorandum, wherein they were seeking certain parities in wages, my lord. Now, that was only confined to that. Now thereafter, the judgment was passed by the honorable single judge, and in appeal there was certain observations on the basis of which this scheme had to be prepared, my lord. Now, my lord, at no place Government of India was party in those proceedings, my lord. Therefore, ultimately, when the matter went to Supreme Court, the Supreme Court said that Government of India was not a party at any stage. It is not binding at all to the Government of India. So you have a remedy in accordance with law. You can avail that, if at all. So, my lords, this writ petition was filed. Now kindly come to. So, my lord, your lordship, what I wanted to impress upon my lord was that Government of India was nowhere party at any stage. Everywhere, my lord, Andaman Nicobar administration were party.
All right.
Now your lordship will kindly come to paragraph 2. Learned advocate appearing for the writ petitioner submits that issue of remuneration, your lordship, this is important. That was the earlier round.
Yes.
Issue of remuneration to daily rated majdoors appointed by Andaman and Nicobar Island administration and the issue of their regularization received consideration of the High Court. He refers to orders dated 13 December 19 passed in WPA 268 of 18 and December 1922 passed in MA 9 of 2020. Now he submits that the authorities were directed to formulate a scheme for the benefit of the daily rated majdoors by the appeal court.
Right.
Learned advocate appearing for the petitioner submit that since the authorities did not comply the direction of High Court dated 19 December 2022, a contempt petition was filed. Being aggrieved by one of the orders passed in contempt petition, the authorities approached to the Honorable Supreme Court. Before the Honorable Supreme Court, an exercise was undertaken to formulate a scheme for regularization for DRMs. Now, my lords, I'll just pause for a moment and submit before your lordships that at no stage Union of India, Government of India was party, my lord. Any of the ministries or departments was party.
All
now,
right.
my lords, then learned advocate appearing for the petitioners draw the attention of the court to the order dated 14th August 2023, passed in Civil Appeal number 5014 of 2023. He submits that the statements made by the administration with regard to the formation of regularization scheme was noted therein. Then, my lords,
Mr. We have actually seen paragraph 5. So
lordships,
we are never a party, and this scheme was sought to be formulated by the administration by this 2023 this scheme.
lordships,
Up to paragraph 5 is your involvement was not there.
my lords,
So paragraph 6, your involvement starts when a letter was given by the administration to you.
lordships.
So let
Now,
us
my lords,
there if you
Your
like.
Lord, now, learned advocate appearing for the petitioners draw the attention of the court to the letter dated 30th August 23, issued by the administration to the Ministry of Home Affairs. In particular, he draws the attention of the court to the contents of such letter, where meeting between being held under the chairmanship of Learned Attorney General of India at New Delhi on 7th August 2023, August 10, 2023, and August 12, 2023 were stated. He states that administration accepted the fixation of cutoff date of 10 years continuous service of DRMs as on August 1, 2023, instead of April 10, 2026, since only about 10 DRMs out of 7,520 would be eligible if cutoff date is considered as on April 10, 2006. He also points out that the distinction between daily rated mazdoors working against sanctioned post or otherwise was removed. Learned advocate appearing for the petitioners draw the attention of the court to the letter dated August 30, 2023, by which the administration sought concurrence and ratification of the scheme of 2023 from the Ministry of Home Affairs. He submits that such letter refers to the advice of Learned Attorney General of India on the issue. He submits that the scheme of 2023 was formulated in accordance with such advice. Learned advocate appearing for the petitioner submit that the civil appeal number 5014 and the order dated September 9, 24 was passed. He submits that the issue of regularization, since Department of Personnel and Training Union of India was not a party to the earlier proceedings, parties were left open to avail their remedies before the appropriate court. He submits that the writ petitioners are now before the court since the DOPT is not according sanction to the scheme of 2023 formulated by the administration. Now, my lord, learned ASG appearing for the respondent submit that no special circumstances exist in Andaman and Nicobar Island for the authorities to extend any special benefit to any DRM who work there. She submits that authorities are bound by the ratio of 2006-4 SCC, Secretary of State Karnataka and the versus others versus Umadvi, and 2010-9 SCC, State of Karnataka versus MLKC. She submits that the scheme of 2023 does not adhere to the parameters laid down therein. Therefore, no approval can be granted to such a scheme. Learned ASG submits that no similar scheme as that of the scheme of 2023 is prevailing in any part of the country. She also points out that the issue as to the legality, validity, and sufficiency of the scheme was kept open, as will appear from the order dated 9 September 24 passed by the Honorable Supreme Court. Therefore, according to her, the scheme not being in accordance with the pronouncement of Umadvi and MLKC, the same was rightly not approved by the department. The scheme cannot be directed to be implemented as against the administration. Then Learned ASG submits that in terms of a scheme, and one-time exercise was undertaken and that 122 DRMs were regularized. The scheme of 2023 is not an open-ended scheme. It is for one-time implementation which occurred. Therefore, question of directing implementation of the scheme of 2023 does not arise. Now, my lords, from here is the discussion.
Yes.
Plights of DRM fell for consideration of the High Court in a writ petition being WPA number 268 of 18. Such writ petition was disposed of on December 13, 2019. Direction for ameliorating the plights of DRM were issued. Now, my lords, here, my lords, I pause for a moment and I will take your lordships to that. My lord, no issue of regularization was there in my lord writ petition, my lords. The issue of wages remuneration was there, my lords. No issue, no direction was issued, my lord. That I will take your lordships to. Then, my lords,
Yes.
being aggrieved by the direction. Now, my lord, even with respect to the parity in the remuneration, the administration was aggrieved and it preferred an intra-court appeal, my lords. Now, therefore, being aggrieved by the direction contained in the order dated December 13, 2019, passed in WPA 268, an appeal was carried as MA9 of 2020. MA9 of 2020 was disposed of by an order dated 19 December 2022. By the order dated December 19, 2022, the appeal court modified few directions of the learned single judge dated December 13, 2019, passed in WPA. Appeal court recorded that benefits extended to DRMs under the circular dated 22nd September 17 will accrue only with effect from the date of the circular and not before that. So far as the benefits of the earlier circular dated 7th June 1988 is concerned, the same remained preserved and undisturbed to be agitated in the event any person is aggrieved by any scheme proposed by the administration. Appeal court by the order dated 19 December 2022 required the administration to frame a scheme of all DRMs. Now, for the first time in appeal court, now that was not even the subject matter, certain observations and directions were made with regard to preparation of a scheme. Now, my lords, thereafter, administration did not implement the order dated 19 December 2022, passed by the appeal court. Contempt petition was filed, being aggrieved by one of the orders of the appeal court passed in contempt jurisdiction. Administration approached the Honorable Supreme Court, which was registered as Civil Appeal 5014 of 2023. Civil appeal was disposed of by the order dated 14th August 23, while noting various aspects of the matter. Honorable Supreme Court in August 14, 2023 also recorded the stand of administration with regard to the regularization scheme. In fact, affidavit filed by the administration before the Honorable Supreme Court was set out in extenso with regard to regularization. Para 11 to 20 of the additional affidavit was quoted in the body of the order. Before the Honorable Supreme Court, the issue as to cutoff date commencement of regularization scheme was deliberated upon. It was found that in the event the cutoff date was taken as April 1, 2006, in terms of Umadvi 3, then only 10 out of 7,520 DRM will be benefited. The fact that if the cutoff date was taken as on August 1, 2023, then 4,440 DRMs would be covered was noted. The stand of the authorities that if the cutoff date of August 1, 2023 should be taken, as then 59% of the total DRM would be become eligible for the regularization was placed on record. In the additional affidavit filed in such contempt proceeding and as noted by the Honorable Supreme Court in the order dated 14th August 2023, in addition to the cutoff date for regularization scheme, other aspect as to whether the DRM should be appointed against sanctioned post or not was also considered. Administration took the stand that DRMs across the board will be taken into consideration in the scheme of 2023, irrespective of whether their initial appointment was against a sanctioned post or otherwise. Then, paragraph 20 of the additional affidavit filed before the Honorable Supreme Court in civil appeal noted that all the steps for regularization was subject. Now, this is very important.
Yes.
All the steps for regularization were subject to concurrence and ratification of the Department of Personnel and Training. So, because the fund was not there with the administration, the money had to come from the Government of India, from the Consolidated Fund of India. Therefore, their concurrence and their approval was necessary. Without that, it was only a piece of paper. Now, then administration issued a notification of August 23, which formulated a scheme for regularization of DRM working under the administration called the Andaman and Nicobar Island Casual Labor Daily Rated Mazdoor Engagement Scheme 2023. The scheme of 23 removed the distinction between DRM working against sanctioned post or otherwise. Then, it also prescribed cutoff date as August 1, 2023. There are other aspects in the scheme of 2023 which need not be alluded in detail the present context. Removal of distinction between working against sanctioned post and prescription of the cutoff date are primary ground of objections. Then, this is very important, para 20. By a letter dated 30th August, the administration wrote to the Ministry of Home Affairs seeking concurrence and ratification of the scheme of 2023. In the body of the letter, the fact that multiple high-level committee meeting was convened under the chairmanship of Learned Attorney General of India in New Delhi in August 7, 2023, August 10, 2023 and August 12, 2023 were also noted. The advice of Learned Attorney General of India was also noted in the body of the letter dated 30th August 2023. The relevant portion of the letter dated August 23 is as follows. This is all part of the scheme. Then, para 22. The letter dated August 30th.
Sir, Sanjay, para 21 contains the advice of the Advocate General. Sorry, the Attorney General.
Your Lordship. Yes, it was in the scheme. This is incorporated in the scheme, my lords.
All right.
Then, my lords, the letter dated August 30, 2023 noted that the scheme was formulated consequent upon the advice given by the Attorney General of India. So it is based on the deliberations and advice the scheme was formulated.
Yes.
Now, my lords, it also noted that the additional affidavit was filed before the Honorable Supreme Court on August 10, 2023, wherein an undertaking was given to the Honorable Supreme Court, and thereafter the civil appeal was disposed of by the Honorable Supreme Court of India. By a letter dated August 30, request was made to the Ministry of Home Affairs to take up the matter with the Department of Personnel and Training, Government of India for approval of the scheme, so that compliance affidavit can be filed before the Honorable Supreme Court in civil appeal number so and so. By a letter dated 13th December 2023, Ministry of Home Affairs wrote to the administration stating that it did not agree with the scheme. In the present format, it enumerates 6 reasons why Ministry of Home Affairs did not agree with the scheme of 2023 as it stands. Essentially, Ministry of Home Affairs in the letter dated December 13, 2013 referred to the pronouncement in Umadvi and ML Kesari's case on regularization of workers appointed against sanctioned posts. It also referred to the cutoff date as prescribed in Umadvi, that is April 10, 2006. It also noticed that 121 DRMs were regularized by the administration. The same objection of the Ministry of Home Affairs recorded in the letter dated 13 December 2023 are reiterated by Learned Additional Solicitor General in course of the submission made today. Then, miscellaneous application was made in civil appeal before the Honorable Supreme Court. Such miscellaneous application was disposed of on September 9, 2024. by recording that as regards issue of regularization, since Department of Personnel and Training Union of India was not a party to the earlier proceedings, any substantive grievance with regard to the scheme for regularization would be open for consideration before appropriate forum. Umadvi 3 issued a direction that the authority should take steps to regularize as one-time measure the services of irregularly appointed personnel who worked for 10 years or more in sanctioned post, but not under cover of orders of the court or tribunal. The process was directed to be set in motion within 6 months from the date of the order. Umadvi 3 was rendered on April 10, 2006. It is nobody's case that process directed by Umadvi was undertaken by the administration or the objectors herein within the time fixed by Umadvi. Respondents cannot be allowed to take advantage of its own wrong, of its wrong in not implementing Umadvi 3 within the time specified therein. While taking such a date of effect as April 10, 2006 in terms of Umadvi, it was found that only 10 DRMs out of 7,520 would become eligible. This issue was considered by high-level committee chaired by the Learned Attorney General of India. Several meetings were held, so and so, so and so, so and so. Such meetings, the Learned Attorney General advised the administration as noted in paragraph 21. ML Kesari considered Umadvi 3. In particular, it considered the exception contained in para 53 of Umadvi 3. It is of the view that two mandatory and cumulative preconditions for regularization of irregular appointment as one-time measure is required to be made. It clarifies that appointment of qualified person made against sanctioned post without following process of open competition are irregular appointments, and appointments made not against sanctioned post or appointment of unqualified person are illegal appointments. Only regular appointees are entitled to regularization in terms of para 53 of the Umadvi 3. Then, my lords, neither Umadvi 3 nor ML Kesari can be read and construed to mean to penalize employees engaged over substantial period of time, albeit on contractual or temporary basis, and made to discharge perennial nature of job. Umadvi 3 and ML Kesari sought to curtail the practice of backdoor entries. Umadvi 3 emphasized the need for appointments following the constitutional principles. Para 32 minutes. Mandatory direction of the appeal court contained in the order dated 19th December 2022 passed in MA requiring the administration to formulate a scheme for regularization of DRM was not challenged by the administration. The issue is binding on the parties. It could not have been made binding on us, my lord. Virtually, the Honorable Single Judge has, even though knowing fully well that we were not the party, so there was no occasion for us to challenge it. So this could not have been made. So completely, my lord, my submission, it's an error of record, my lords. Then, my lords, the respondent herein are therefore obliged. So respondent herein are we, my lords, not the administration.
Yes.
The respondents herein are therefore obliged to frame a scheme for regularization. Administration did frame a scheme, which is the scheme of 2023. Now, Department of Personnel and Training is refusing to concur with such a scheme on the ground as noted above. Neither the administration nor the Department of Personnel and Training can be heard to contend successfully that the scheme must be limited to person as on April 10, 2006 and not 1st August 2023 as formulated under the scheme. Now, firstly, neither the administration nor the Department of Personnel and Training formulated a scheme for regularization in terms of in Umadvi within 6 months as stipulated therein. This is also not erroneous, my lord. It was also done that time. Therefore, the respondent cannot take benefit of their own wrong in contending that the scheme should be for person in employment on April 10, 2006 and none else. Secondly, the administration continued to engage persons on temporary basis as DRMs subsequent April 10, 2006, despite the mandate of Umadvi, requiring all Article 12 instrumentalities, including the respondents herein, not to do so. Fact that the DRM were appointed subsequent to April 10, 2006 is borne out from the formulated scheme of 2023 itself. Moreover, formulated scheme of 2023 prescribes a cutoff date of August 1, 2023 for persons in employment of 10 years prior thereto. This fact itself establishes that the appointment were granted subsequent to April 10, 2006, contrary to Umadvi 3. On the parity of same reasoning as in the previous paragraph, shelter of Umadvi and ML Kesri is not available to the respondents for the purpose of considering whether the appointments were against sanctioned post or otherwise. The respondent continued granting appointments to DRMs both against sanctioned post and otherwise subsequent to Umadvi. There is no explanation as to why the respondents indulge in such practice. There is no material on record to establish that any steps were taken against the person who indulged in such practice within the administration in giving such appointments in violation of Umadvi 3. Then, my lord, application of Umadvi cannot be limited to the helpless DRMs with no consequences befalling the administration who violated the same. Umadvi and ML cases are not intended for a unilateral application by way of penalty against DRMs. With the deepest of respect, such an interpretation of Umadvi and Kesri would be limiting them to measure of penalty against DRMs. That would be contrary to the letter and spirit of the ratio laid down therein. The scheme in question was formulated after obtaining the advice of Learned Attorney General of India. The ground of objection sought to be raised by the Department of Personnel and Training were considered as appearing from the body of the letter dated August 30, 2023 itself. There is no material to suggest that any scheme for regularization was even floated for the subject 7520 DRMs who would be benefited. Those 7520 DRMs are therefore entitled to one scheme of regularization in terms of Umadvi, if nothing else. The issue of implementation of a scheme of 2023 as a one-time measure will arrive only when the scheme is approved. As on date, the scheme of 2023 is yet to be approved by the Department of Personnel and Training. The question of one-time implementation of such a scheme prior to formulated scheme of 2023 therefore does not arise. In view of the discussions and above, objections of the Department of DOPT cannot be accepted. Such department is directed to accord approval of the scheme of 2023 as notified in August 23 by the administration within 4 weeks from the day. Now, my lords, merely because a scheme had to be framed because of the threat of contempt, my lords, and therefore it is said that now it will be thrust on the government of India and you are directed to regularize all 7,520 irrespective of whether they are individually, my lord, entitled for any such or not. My lord, complete backdoor entry that huge persons whose name has been included, who then no, my lord, recruitment process was prescribed, no qualification, no sanctioned post, nothing. But the Honorable Single Judge has been pleased to direct that a mandamus is issued to the Government of India, who were never the party in earlier round of litigations, that you have to bear the burden of entire, without considering the financial implication at all, my lord, of such a huge number of employees. Now, who were working, who were not working, nothing, my lord, that nothing has been considered, my lord, in detail. And it is in this way this order has been passed, and therefore we are before your lordships.
Mr. Sanjay, one question to you. Para 35 Learned Single Judge says that neither the administration nor the Department of Personnel formulated a scheme for regularization in terms of Umadvi at the relevant point of time within those 6 months. So, did you have that? I mean, we are thinking about as the Learned Single Judge says, the hapless workers. I mean, they cannot be in the lurch. I mean, did you? Yeah, just elaborate on that. Administration, we can understand, yes, they had a role to play. We will come into them later, but role to play in Umadvi.
I'm sorry, can I get it again? Perhaps there was some problem in the voice.
Our question is, can you hear Mr. Shanle?
No, your lordship, yes.
Yes. In para 35, the Learned Single Judge makes an observation that neither the administration nor the Department of Personnel formulated a scheme for regularization of Umadvi within 6 months. So apparently we are also rather concerned about the hapless workers. Well, definitely all of us are. I mean, the should also be concerned about the hapless workers otherwise. But the question is whether the non-formulation of the scheme in terms of Umadvi at the juncture did EU because obligation is also neither the administration nor the formulated scheme in terms of 6 months, which came up as well. So you also believe
Time during 6 months, did you free the scheme?
Lord, what I have understood, Lord, that whether after the judgment of Umadvi
Yes.
within 6 months
Right.
or even subsequent thereto, even thereafter, any scheme was formulated or not, my lord?
Yes.
That is the question, my lords, my lord, as has been
True.
observed by the learned single judge, honorable single judge.
Yes.
My lord, yes, there were two schemes, and
Ah.
that was argued before the honorable single judge. Now, those schemes were framed by the administration and regularization was made. My lord, if that your lordship will kindly see, my lords, paragraph 11 first.
Right.
If your lordship will see.
Acha, this 122 DRMs. Acha.
My lords, your lordship will see 122 DRMs were regularized that time. my lords.
But the learned ASG at that point of time submitted that in
Look.
terms of scheme of 2023, a 1 exercise was undertaken.
No. This is,
Para 11 says that.
but learned additional studies submit that in terms of scheme of 2023. Now, my lord, 122 DRM were regularized.
So,
This appears to be some error, my lord, in recording, my lord, because at
yes, please.
that point of time, scheme was formulated and regularization was done, my lord. 122 persons were regularized, my lord.
So this was not in terms of
Actually, the completion of the regularization was made in 2021, my lords, not in terms of 23, my lord.
Yes.
It started in 2015, my lords,
Acha.
and completed in 2021. So there is no question of regularization in terms of this scheme of 2023, my lords. One-time measure was done, my lords.
All right. So
Your
do
lordship.
anything on record to show that? Was it placed before the learned single judge or anywhere that these measures were taken?
Yes, my lord. This is not in dispute, my lord, because in earlier round also,
Right.
this had come, my lord. Now, if your lordship will now see, my lord, since, my lord, the entire judgment of the honorable single judge,
Yes.
my lord, it harps on the earlier round of proceedings, my lords. Now, then in that case,
You can appreciate, Mr. Sanjay, it's evident that you were party who bound that and you were for violation, so-called violation of that. It was on the administration and that's subject to your concurrence. So you say you did to isn't that?
now, my lords, one more important aspect, my lord, that, my lord, with respect to any appointment having financial implication was required from our concurrence, my lord. My lord, so much of, my lord, persons are being employed was never within the knowledge of Government of India, because we have never concurred to engage such large number of persons from. And it is also mentioned in the scheme that it was never brought to the notice, because always the Government of India has written, my lord, unless with so it's on sanction post only, make recruitment on the basis of the recruitment rules by proper advertisement, by proper my lord, process of following process of examination. Now then, now if your lordship will have pleasure to see the now, my lords, I would like to, my lord, show first time, my lord, single. My lord, if your lordship will see the 76. My lord, from the paper book, if your lordship will kindly turn to page 76, my lord, first. Annexure A7, my lords. Operative forcing. It starts from page 76, my lords.
Yes.
Lordship got it, my lords. Now, my lord, I would just like to show to my lords one paragraph or two paragraph only.
Yes.
Now, my lord, kindly see here. What is the prayer which was made against the administration?
This was the application, Mr. Sanjay?
First, your lordship, first round.
Right.
And for my lord, incidentally, before honorable the same judge, my lord. Honorable Justice Bosak is the judge.
Yes,
before whom? Now, my lord, the petitioners have sought a direction upon the authorities to grant the benefit of 1/30th pay of minimum of relevant pay scale plus dearness allowances in terms of office memorandum dated 7th June 1988 to all daily rated employees working under the respondent number 5 on and from the date of their initial engagement. Now, my lord, this writ petition is filed in 2018, my lords. Kindly note it, my lords.
Yes.
So this writ petition is filed for the first time in 2018, and no prayer or relief of regularization is being sought, my lord. It is only with respect to, my lord, benefit of 1/30th pay of the minimum of the relevant pay scale plus dearness allowance in terms of office memorandum dated 7th June 1988 to all daily rated employee working under the respondent number 5. That is the administration, my lords. And now, my lords, kindly see the operative portion of the judgment, my lords,
Yes.
at page 81, my lords. Last but one paragraph.
Yes.
Now, my lords, rather, my lord, my lordship, permit me to place from paragraph 2 onwards of the page 81.
Yes.
If the problem of a daily rated casual worker, now, my lord, daily rated casual worker discharging duties of an unsanctioned post is considered from another perspective, that is to say that supposing the post of peon for one department is not sanctioned and daily rated casual worker is called upon to discharge the duties of peon in respect of such unsanctioned post, and on the same day another daily rated worker is engaged by the same department in respect of a post of similar nature but sanctioned, then the administration will be unlawfully discriminating between these two persons. In my view, these two daily rated casual workers are similarly situated and circumstances and cannot be discriminated against by the administration simply on the ground that in the case of one post is sanctioned and the case of the other, the post remain unsanctioned. In both the situations, the administration is deriving advantage of the work and duties discharged by the daily rated casual workers. In both the situations, daily rated casual worker is required to discharge the duties as assigned to them. In none of the two situations can any of the daily rated casual worker claim that they will discharge lesser duties than they assigned to them on the ground that one of them will receive the lesser pay in relation to other. Workers are entitled to equal pay for equal work. On such a principle, an intelligible differentiation cannot be brought about between the daily rated casual worker engaged to do work against a sanctioned post and a worker engaged to do work against a post which is not sanctioned. The memorandum dated 27 September 17 gives benefit to a section of daily rated casual workers. Quashing such memorandum in its entirety might lead to complications. Therefore, it would be appropriate to read the memorandum dated 22nd September 17 so as to confirm with the office memorandum dated 7th June 88 and the principle that must be equal pay for equal work. In such circumstances, the impugned office memorandum dated September 12, 2017, 22, 2017 is read to mean that it will apply to all daily rated casual workers engaged by the administration, irrespective of the department and irrespective of the fact that the post against which they were discharging duties are sanctioned or not. The impugned office memorandum dated 22nd September 17 is also read that all the daily rated workers engaged by the Andaman and Nicobar administration in any department will be entitled to 1/30th of the pay at the minimum of the relevant pay scale plus dearness allowance for work of 8 hours a day on every day of their engagement on or from June 7, 1988. So this was the decision by the Honorable Single Judge. Now, against this judgment, it appears that the administration felt aggrieved with why they have been subjected to this direction by the Honorable Single Judge. So they preferred an appeal, my lords, before the Honorable Division Bench. Now, my lords, kindly see the judgment of the Division Bench. It starts from page, my lord, 90, sorry.
83.
Page 96, my lord.
No, no,
Your lord.
83 in the paperwork, Mr. Sanjay. Got it. We've got it. 83 in the 83 now.
Lordship.
December 19, 2022 order.
Your lordship.
Right,
My
right.
Okay. Now, my lords, kindly see. So, my lord, that order and the operative part was subjected to challenge before the division bench, my lord. Now, what happened, my lord? If your lordship will see, my lord, first page is the only introduction. Then, my lords, page 2, my lord, next page, internal page 2.
Yes, yes.
The thrust of the argument of administration is that the memorandum dated 22nd September 17 is a one-time standalone measure to enhance the remuneration and wages payable to all the DRMs. There is absolutely no reference to memorandum dated 7th June 1988. In the said memorandum is dehorsed the same. The memorandum is a standalone policy decision for enhancement of rate and remuneration of DRMs under the administration and cannot be understood to have arisen out of the memorandum dated 7th June 1988. Now, then, my lords, having heard learned ASG, Mr. Banerjee, for the appellants and learned counsel, Mr. So and so, this court is of the view that the memorandum dated 22nd September 17 is a standalone policy decision of the administration for enhancement of wages and remuneration payable to the DRM who fulfilled certain criteria. There is, in fact, no reference of 1988 memorandum. So, my lord, to this extent, the order was modified. The right of the writ petitioners and all DRMs in the UT under the memorandum dated 7th June 88 remain protected and can't be enforced. Dehorse any claim made in these proceedings under the office memorandum dated so and so. Now, my lords. Now, my lord, here, my lord, for the first time, if your lordship will see page 3. Now, the problem started here only. In fact, now, my lord, it was nobody's case nor any prayer, my lord, before this appeal court, my lord. Now, in fact, it is submitted by administration and affirmed by learned counsel for the writ petitioner that the administration had already commenced implementation of memorandum dated 7th June 88. It is therefore ordered that the circular and process of framing of a scheme for regularization and every other benefit under the aforesaid 88 circular duly addressed would mandatorily and positively be brought into force within next 3 months. Now, my lord, this appeal was by the administration against those organizations. We were nowhere in picture, my lord. We had nothing to do with this. Now, it appears that this is a direction by the court that a scheme for regularization and every other benefit under the aforesaid 88 circular duly addressed would mandatorily and positively be brought into force within next 3 months. Now, learned ASG Mr. Vikramjit Banerjee in his usual fairness offered to use his good offices to prevail upon administration in this regard. Insofar as the impugned judgment is concerned, this court is of the view that one-time measure and a policy decision of UT as contained in the memorandum dated 22nd September 17 must be implemented. This court is also of the view that the single judge may have to some extent gone by the averment made by the administration in its affidavit in opposition and had interlinked memorandum dated 7th June 88 with the memorandum dated 22nd September 17. The direction of the single judge to that extent are modified. The benefit to the DRMs under the circular dated 22nd September 17 will accrue only with effect from the date of circular and not before that. Insofar as the order and directions of learned single judge are concerned, that no distinction should be made between DRM working against sanctioned post and DRM against casually by the state, this court upholds the same. This court orders that all DRM under the administration shall be paid and granted the benefit of circular dated 22nd September 2017. So, my lord, irrespective of sanctioned post or non-sanctioned post, they were all given this benefit. Now, my lord, this order, my lord, on the basis of this order, the demand was raised by the administration from the government of India. And, my lord, government of India, my lord, initially what happened, that administration did not comply this order. As a result was, my lord, that a contempt was initiated.
I'll say, Mr. Sanjay, sorry to disturb you. Now, there are two components of the appellate court's order, appellate benches. Now, 22nd September 2017, either side.
Lordships.
But you say that the appellate court, it was nobody's case regarding the 1988 scheme, but taking a cue from that scheme, it was directed that a scheme should be formulated on that basis. And then the scheme was formulated, for the administration forwarded to you.
Lordships.
Did not, that's where content arose.
So it has taken from 2006 onward till 2023.
Yes.
So
Right.
7,520 persons
That was
included.
7 June 1988, right?
Lordships. It has
Right.
taken from that period.
Well,
Now,
Yes.
my lords, after this,
yes.
my lord, till this stage, we were not at all involved, my lord.
No,
Even
no.
after this matter went to,
Content.
no scheme was formulated by them, my lords, within the time fixed by the, my lord, 3 months, my lord, it was not perhaps possible, but then we are not concerned with that. So, my lord, what happened? A contempt proceeding was initiated.
This is
Now,
that,
your lordship will
Gunakumar?
kindly come to,
Yes.
now, my lords, your lordship will kindly come to the, at page, my lords,
Let's
155 in the paper book. my lords.
Honorable has given.
Also available that all
Yes.
One minute. Administration appears to have been aggrieved
Hmm.
that
Hmm.
sanction and non-sanction, everybody should be given. So therefore, it appears that they did not implement it.
Right.
And they were still deliberating it, my lord. After 3 months, a contempt was filed.
Hmm.
And if your lordship will kindly come to page 155.
Yes. Pages
the
will
contempt-
not tally because pages will not tally.
Oh, I'm sorry. I'm sorry.
order dated.
My lord, this is order dated 3rd August 2023, my lords.
3rd August 2020. 90.
My learned friend will,
Yes,
perhaps-
yes, we will take the corresponding.
Yes.
Yes.
lordships.
Page 19.
Yes, you have got it. Page 90.
Lordships, Lord Miller. Mr. Vikramjit Banerjee places an affidavit of compliance filed by so and so. The contemnants have not even bothered to file any affidavit. This conduct of expressai contumacious, and they have reduced the contempt jurisdiction of a division bench of this court under Article so and so mockery, perhaps. The purported affidavit of compliance dated 2nd August throws a challenge to the order dated 19 December 2022, where specific and clear directions have been made. The said order remains unchallenged today as on date. Finding of this court as recorded on 22nd July are clear and explicit. The undertaking required by the administration from the DRM as a precondition for release of payment has not been withdrawn till date. Mr. Banerjee submits that he has held a conference with the administration and the administration has conditioned to withdrawing the requirement of signing the undertaking. This court finds that the purport affidavit of compliance saying nothing about framing of any scheme. Now, my lord, here it is important.
Yes.
The court finds that purported affidavit of compliance saying nothing about framing of any scheme or illegal and contumacious distinction sought to be drawn between the DRMs engaged against sanctioned post and those DRMs which are not engaged against any sanctioned post. In essence, particularly paragraph at 16 of deponent of the affidavit has the audacity to challenge and reopen the issue decided by the single bench and confirmed by the division bench without challenging the same before the higher forum. This court clearly finds flagrant and reprehensive contempt on the part of the contemnants, Admiral D.K. Joshi, Lieutenant Governor, Andaman and Nicobar, and Sri Keshav Chand, the Chief Secretary, Andaman and Nicobar Administration. In view of the above, in view of the conduct of the contemnants indicated here above, this court is left with no option than to direct that the contemnant number 2, Sri Keshav Chand, Chief Secretary, Andaman Nicobar, be suspended forthwith. The next senior most officer in the administration shall take over and discharge the function of the Chief Secretary. Then next paragraph. In view of the blatant contumacious conduct of Admiral D.K. Joshi, this court directs him to deposit with the registrar of the Port Blair bench of High Court of Calcutta a sum of 5 lakhs from his own funds from within a period of 7 days of date. On the adjourned date, Admiral D.K. Joshi, Lieutenant Governor, shall appear in virtual mode and the Chief Secretary, Andaman and Nicobar, shall be personally present in this court and show cause why they should not be committed to prison for having committed contempt of court as already found against them. Let this matter stand adjourned and listed on 17th August 2023. pendency of the proceeding shall not prevent the administration from complying with the orders of the court. Get a copy of this sold to Ministry of Home Affairs, Public Grievance Pension, so at New Delhi, Registrar General Court to Contempt. Now, my lord, against this, SLP was filed against this order of contempt, my lord, directing to suspend the Chief Secretary.
Due respect, Mr. Sanjay, we don't know whether we could make this comment or not. The appearances, no, what you are anticipating, but something else. Well, we see the appearances for the arrest container number 1 before the Supreme Court, and the advice was given by the same person, that advice on which you did not act in a different capacity. We think there is a conflict of interest in our standards are, anyway, let us forget that. Yes, let's continue. Yes.
Now, my lords, if your lordship will come to the order of Supreme Court, my lord.
Yes, it was stayed.
Lordships. And my lords, no, my lord, the entire effort was to save the officers from contempt.
Yes, yes.
And no proper, my lords, application could be made, my lord. The entire administration was to protect their highest officers.
Yes, yes, absolutely. And anyway, let us not discuss that in. Yes, you understand what you are saying, and you, vice versa. Yes.
So, my lord, in these circumstances,
Yes.
Under this threat of contempt and all these meetings were held, and then to protect them, my lord, a scheme was hurriedly formulated, and then it was sent to the government of India, my lord. My lord. And one more thing which I want to, my lord, show to my lords, my lord, from the order of the Supreme Court.
Yes.
My lord, if your lordship will kindly come to that, my lord, it starts from page.
Yes, we are there. We have got it. Yes.
Lordship could get it, my lord, but internal page.
Order dated 14/8/2000.
My lord, sir, it is order dated.
That is a final.
14 August 2008.
Thank you.
My lord, 14th August 2023, my lord, if your lordship will have pleasure to see.
Yes, yes, yes.
Fine, my lords. Now, my lords, your lordship will see internal page 6, my lord, of the order. Paragraph 11.
Paragraph 11, yes.
Your lordships. Now, my lord, the direction issued by the High Court for the suspension of the Chief Secretary was grossly disproportionate. Moreover, such a direction is extraneous to the exercise of the contempt jurisdiction. The direction of the Lieutenant Governor to deposit rupees 5 lakhs, even though the contempt proceeding was still to be heard, finally is plainly unsustainable. The administration has, during the pendency of the proceeding, taken steps to withdraw the offending clause of its order dated 9th May, order so and so, and has enhanced wages shall be implemented with effect from 1st September 17. Moreover, order 2276 is to pledge that arrear shall be payable from 1st September 17 to 8th May to 4010 DRMs. The administration has requisitioned fund to the tune of rupees 300 crores under the wages head, which is under consideration before the Union Ministry of Home Affairs. Moreover, it has been stated that regularization scheme would be framed in terms of a statement which made before the division bench of the High Court. It has been clarified in the additional affidavit. In this view of the matter, we are of the view that the exercise of contempt jurisdiction would not be warranted. All action in compliance thereof shall be completed positively by 30th November 2023. The contempt proceeding before the High Court stands closed. And no direction to the Union of India, my lords. Now, kindly see, my lord.
It was under consideration before the Union Ministry of Home Affairs.
That was, my lord, with respect to payment of 300 crores, my lord, pursuant to the direction of the learned single judge, my lords.
Right.
Affirmed by the division bench, my lord. Now, my lords, kindly see one more order of the Honorable Supreme Court. Follow page. That is, my lord, page. Order dated 9/9/2024, my lords.
9/9/2024.
Annexure A21.
Just check that.
Page 174.
Thank you so much.
Lord, I'm sorry, I'm bothering your lordship because of the page number, my lord.
No, Leonard, counsel for the Mazdur Sangh is kind enough to assist you.
I'm grateful to my learned friend.
We've got it, Mr. Sanjay. Yes.
Lordship. Now, my lords, kindly come to the second page of the order, my lord. It says, upon hearing the counsel, the court made following order. Now, my lords, the payment which was envisaged in paragraph 11. Lordship could get it, Milords?
Yes, you have got, yes.
Lordship. The payment which was envisaged in paragraph 11 of the order of this court, dated 14th August 23, has admittedly been made. So, Milord, Government of India made the payment, Milord. When the matter was sent to the Government of India with respect to that part, it was done. This is not in dispute by Mr. Gopala Kumar Binu, counsel appearing on behalf of the respondents. Learned Attorney General also states that the payment has been made.
Oh, the 300 could sum. 300 could. Mr. Selvar,
Lordships,
this is this that amount which has been
but I'm sorry,
sorry. The previous order to placed before us that referred 300 crores to be paid and all.
yes, that 300 crores. Yes, Milord. Paragraph 11.
This is the
Yes, that entire amount has been paid, Milord.
right.
With respect to Milord, that is remuneration, Milord, equivalent to those.
Yes.
Enhanced remuneration to all, Milord. In compliance to the direction to sanction, non-sanction, all. It was honored, Milord. Now, as regard the issue of regularization, it is common ground. Now, this is important. It's common ground that the Department of Personnel and Training Union of India was not a party to earlier proceedings.
Yes.
In this backdrop, all that need to be observed at this stage is that if there is any substantive grievance with regard to scheme of regularization, it would be open to the respondents to pursue their claim in accordance with law. The miscellaneous appeal application filed by Union of India is accordingly disposed of, not pressed at this stage. So, Milord, it was closed, Milord. Now, Milord, the second writ petition could not have carried the legacy of the first petition, Milord. The scope was completely different in the first petition. But it appears that the Honorable Single Judge has carried that and, Milord, importing everything from that petition, has said that the government of India is bound to accept the scheme which has been formulated, irrespective of whether the government of India has any right to examine it or not, and it will have impact of thousands and thousands of crores on government of India, on public exchequer, Milords. Now, Milord, who were the casual employee, who were the daily rated employees when he started working till when he worked, all those 7,520 up till 1988 to 2023, they will be included and they has to be regularized by amendment.
Roughly, what would be the amount which would be then roughly in crores?
In 30,000, 40,000, 10,000 difference will come.
10,000.
Yes.
Now, my God, the dues also have to be paid.
Dues already paid, my lord, so far as 1/30th is concerned.
Well.
So if
Today,
today,
regularization means in regular service, whether posts are there or not there, because casual workers are taken when there is a need to take them work, Milord. And now, Milord, it's completely, it cannot be said, Milord, individual cases had to be examined, Milords. So it's not that in one go, everybody has to be regularized, Milord. That is not the scope, Milord. By no scope, Milord, it could have been done, Milord. The manner it has been done. Milord, if it could have been in a proper way to do it, Milord, this should not have been the judgment of the Honorable Single Judge that in one go you do everything. But where from the money will come? The money will, administration does not have money. The money has to come from the government of India, from the consolidated funds.
Asking a question, I mean, this is because you are also afraid of equity, which you know. Now, what would be, can there be in the sense that suppose subject to scrutiny, we understand, accept arguments prior pressure is subject to the other side. But can there be any middle path? I mean, in the sense that subject to scrutiny, scheme maybe, but subject to scrutiny of every individual case, and what would be the parameters which would be applicable then? That they are not that please, they are not covered with fee. Would that be sufficient? I mean, because this established proposition now basically.
Milord, according to the stand of the government of India, Milords.
Yes.
Milord, individual scrutiny will be required, Milord.
Alright.
When a person was taken into service, by what mode, who has taken him in service, and whether he worked actually or not. All these facts will be required to be considered. Then only a decision can be taken on that, my lord. Not merely because the scheme has been framed and then it has been sent, so it has to be accepted by the government of India. This is no way. Now, my lord, what I submit, my lords, that this is a case where the manner in which the direction has been issued by the honorable single judge, that is in law, it is not sustainable. Now, my lord, it cannot have any judicial sanction unless and until with respect to the employees who are claiming to be the casual employee. Now, my lord, they have got all the wages, my lord, for the period they have worked. Now, the question is regularization. Now, regularization means all the benefits of a regular employee, my lord, then one thing is missing, regular selection. Now, my lord, selection, my lord, after adhering to Article 14 and 16, my lords. Now, all those who are in the queue, your lordship, we can't lose sight of the fact that many meritorious people from poor families are waiting in the queue to get themselves, whereas some people through some backdoor entries, through some manner, for working for 1 day or 2 days, they comes in. Thereafter, after some time they work and they start claiming their right to be regularized. So, my lord, my submission would be that it will require detailed scrutiny of each individual worker's, my lord, whether he is eligible, my lord, qualification, experience, my lord, the requirement for a particular work, my lord, will have to be seen. So, my lords, everything will be required to be scrutinized to consider for their regularization. And it is not a case that nowhere such exercise was held. Such exercise was held and people has been regularized. So it's not that fact. And my lord, there are number of judgments. My lord, judgments on given facts of the case, each side judgment, no difficulty. But then the basic principle which my lords have laid down and the Honorable Supreme Court has laid down. Now, my lords, the broad principle are 5-6 categories. My lord, that is only irregular employees, not illegal employees.
Right.
Then, my lords, only against sanctioned post. My lord, post cannot be sanctioned to regularize, my lord. If there is no sanctioned post, then no inherent right of regularization. These are the broad categories, my lord, I'm saying. Because, my lord, employees are also aware of their temporary employment or casual employment or contractual employment.
Yes.
Then, my lords, regularization cannot be a mode of appointment. And then at times length of service is also not material. Because, my lord, casual employees, whenever the need is there, they are. And, my lord, any scheme is a policy decision of the government of India. So unless it is found to be wholly arbitrary, your lordship normally do not interfere. Of course, if your lordship finds it to be arbitrary, completely arbitrary or discriminatory, violative of Article 14, 16 also, my lord, roster is also important consideration in employment, my lord. My lord, regularization is not a source of employment, because then everything is, except the period of working, is ignored, my lord.
Yes, the backbone also comes in. I mean, those, yes.
Your
Right.
lordships. Then, my lords, your lordship, another important consideration is that court must also consider financial burden of directing regulation of employees and exercise self-restraint, my lord. Now, here in the case, already the government of India exceeded, because there was with equal work to equal pay. It has been given, my lords. 300 crores was disbursed to them. So it's not that government has acted in arbitrary manner. They have, my lord, done it. And then, my lords, here is a case where employees are claiming to be of having worked for administration, whereas the responsibility and financial liability is being thrust on the government of India. And even the court does not leave us with the discretion to accept it or not. It says that you have to accept it in toto. That is the problem with government of India. Because, the regularization cases have to be decided on individual fact of the employees who had approached the court, my lord.
Assessment with the.
Absolutely.
So, my lords,
Very well. Yes.
now, my lords, if your lordship will permit me
Yes.
to my lord cite certain decisions, my lord, we have already sent, my lord, the copies of that.
Yes. Yes.
I've submitted one.
And thank you for indicating paragraph numbers.
Lordship, my lord, I always try to assist my lords to the
Yes,
best of my ability, my lords.
Absolutely. Thank you. Thank you very much. Yes.
Lordships. Now, my lord, the first judgment,
Yes.
my lord, is the judgment of Secretary of State Karnataka versus Umadvi 3. My lords.
Yes. See.
Now, my
yes.
lord, straight away, I will invite my lord's attention to the relevant paragraph, my lord. Paragraph 19.
Yes.
It is at page, my lords,
25.
26.
Acha, starts at 25. Yes.
I'm sorry, my lord, page 25, lordship.
Yes. Yes. Yes.
No, no. One aspect arises. Obviously, the state is also controlled by economic considerations and financial implications of any public employment. The viability of the department or the instrumentality of the project is also equal concern for the state. The state works out the scheme taking into consideration the financial implications and the economic aspects. Can the court impose on the state a financial burden of this nature by insisting on regularization or permanence of employment when those employed temporarily are not needed permanently or regularly? As an example, we can envisage a direction to give permanent employment to all those who are being temporarily or casually employed in a public sector undertaking. The burden may become so heavy by such a direction that the undertaking itself may collapse under its own weight. It is not as if this land so happened. So the court ought not to impose a financial burden on the state by such directions, as such directions may turn counterproductive.
Probably the concept of separation of power also comes in a sense.
Lordships.
Executive and judiciary. I mean, we have our own domains. Maybe that policy decision and all those judgments.
Yes. Lordships.
Yes.
Now, my lords,
Yes.
kindly come to one more paragraph.
Hmm.
Paragraph 45, my lords. It is
Yes,
at page,
Mr. Kumar, so that you can answer. Right.
paragraph 45, my lords, page 37.
45. Yes. Page 37. Yes, please.
While directing that appointments, temporary or casual, be regularized or made permanent, the courts are swayed by the fact that the person concerned has worked for some time and in some cases for a considerable length of time. It is not as if the person who accepts an engagement, either temporary or casual in nature, is not aware of the nature of his employment. He accepts the employment with open eye. It may be true that he is not in a position to bargain, not at arm's length, since he might have been searching for some employment so as to echo out his livelihood and accept whatever he gets. But on that ground alone, it would not be appropriate to jettison the constitutional scheme of appointment and to take the view that a person who has temporarily or casually got employed should be directed to be continued permanently. By doing so, it will be creating another mode of public employment which is not permissible. If the court were to void a contractual employment of this nature on the ground that the parties were not having equal bargaining power, that too would not enable the court to grant any relief to the employee. A total embargo on such casual or temporary employment is not possible given the exigencies of administration, and if imposed, would only mean that some people who at least get employment temporarily, contractually, or casually would not be getting even that employment. When securing of such employment brings at least some succor to them. After all, innumerable citizens in our vast country are in search of employment, and one is not compelled to accept a casual or temporary employment. If one is not inclined to go in for such an employment, it is in that context that one has to proceed on the basis that the employment was accepted fully knowing the nature of it and the consequences flowing from it. In other words, even while accepting the employment, the person concerned knows the nature of his employment. It is not an appointment to a post in a real sense of the term. The claim acquired by them in the post in which he temporarily employed or the interest in that post cannot be considered to be of such magnitude as to enable the giving up of the procedure established for making regular appointments to available posts in the services of the state. The argument that since one has been working for some time in the post, it will not be just to discontinue him, even though he was aware of the nature of employment when he first took it up, is not one that would enable the jettisoning of the procedure established by law for public employment and would have to fail when tested on the touchstone of constitutionality and equality of opportunity enshrined in Article 14 of the Constitution. Then, my lord, kindly come to para 48.
The difficulty, Mr. Sanjay, is that taking advantage of Umadvi, so many governments are exploiting the unorganized sectors by giving only contractual appointments. You are aware of the situation, ground situation. We cannot make any comment on that sitting in High Court in our judgments. But this is, I mean,
I'm also conscious of this fact, my lord.
yes, but we cannot, yes, the consideration in Umadvi are binding us, and also not only that, these are also valid considerations. I mean, we appreciate you have set the balance somewhere.
Yes.
It goes into the elected representatives. That is why we argue.
My
Not
balancing is important, my lords.
Yes. But
Has rightly fallen from my lords that
But
your lordship has to balance.
we have a constant thing, so we cannot impose our domain, our dictate maybe. Maybe that's also a valid point. We strike a balance in this judgment. Let us see. Yes.
Kindly come to paragraph 48.
Yes.
It was then contended that the rights of the employees thus appointed under Article 14 and 16 of the Constitution are violated. It is stated that the state has treated the employees unfairly by employing them on less than minimum wages and extracting work from them from a pretty long period in comparison with those directly recruited who are getting more wages or salaries for doing similar work. The employees before us were engaged on daily wages in the department concerned on a wage that was made known to them. There is no case that the wage agreed upon was not being paid. Those who are working on daily wages formed a class by themselves. They cannot claim that they are discriminated against those who have been regularly recruited on the basis of relevant rules. No right can be founded on an employment on daily wages to claim that such employee should be treated on at a par with regularly recruited candidates and made permanent in employment, even assuming that the principle could be invoked for claiming equal wages for equal work. There is no fundamental right in those who have been employed on daily wages or temporarily on contractual basis to claim that they have a right to be absorbed in service. As has been held by this court, they cannot be said to be holders of a post since a regular appointment could be made only by making appointment consistent with the requirement of Article 14 and 16 of the Constitution. A right to be treated equally with other employees employed on daily wages cannot be extended to claim for equal treatment with those who were regularly employed. That would be treating unequals as equals. It cannot be relied on to claim a right to be absorbed in service, even though they have never been selected in terms of relevant recruitment rules. The argument based on Article 14 and 16 are therefore overruled. Now, my lords, paragraph 59. 51, my lord, I'm sorry.
For Gen Z.
Sorry, my lords.
A bit feudal for Gen Z. But not for we are Gen X or previous.
So you can still accept a bit freedom for Gen Z probably. You don't know Gen Z, you don't know the expression. You ask your children or grandchildren about Gen Z. This is a latest expression. Gen Z.
Gen Z.
This is a bit
Yes, yes.
so 52 is the next one which you have
51 minutes, I'm sorry, 51.
Very well.
Para 51. Why I'm reading
Forms the basis of everything. That's why we are reading it in Indian. Most of the judgments.
I am reading this judgment in a bit detail so that I may not refer other large number of judgments.
You understand, Mr. Sanjay, because this is the probably the genesis of many other judgments also.
Your lordships.
Yes.
Even some judgments
Yes.
in which in the given facts of that case, a regularization has been permitted, my lords. They only carve out certain exceptions from this judgment only.
Yes.
But otherwise, this judgment is.
In fact, we have crystallized the parameters. Say those things.
Lordships.
Post, and that is the crux of these judgments.
One observation of my lords, my lord, which has
Yes.
fallen from my lord, that whether there can be any via media.
Yes, we were thinking.
Mid-part. Now, my lords, your lordships, so far that part is concerned, on that issue, we will have to seek instruction that given those who are actually working, then if given a recruitment exercise can be made, giving them age relaxation,
Yes.
but then to following the parameter of eligibility, etc., and their experience may be given some weightage.
Yes.
So all that can be done, but not such a blanket order is acceptable to Government of India.
No, we
That,
understand. We understand fully. Yes. Yes.
because otherwise, this will be amounting to discrimination with all those who are in the queue, who wanted to be, otherwise there was no need of any recruitment. If 7,500 people are employed in Andaman and Nicobar,
We understand.
then what will happen to the children of those persons who have studied there and who are in the queue to get employment in the Andaman Nicobar administration government, and this is the paragraph,
Right.
51. The argument that the right to life protected by Article 21 of Constitution would include the right of employment also cannot be accepted at this juncture. The law is dynamic and our Constitution is a living document. Maybe at some future point of time, the right to employment can also be brought under the concept of right to life or even included as a fundamental right. The new statute is perhaps a beginning. As things now stand, the acceptance of such a plea at the instance of the employees before us would lead to consequences of depriving a large number of their other aspirants, of an opportunity to compete for the post or employment. Compete for the post of the employment. Their right to employment, if it is a part of right to life, would stand denuded by preferring of those who have got in casually or those who have come through back door.
Yes.
The obligation cast on the state under Article 39A of the Constitution is to ensure that all citizens equally have a right to adequate means of livelihood. It will be more consistent with that policy if the courts recognize that an appointment to a post in government service or in the service of its instrumentalities can only be by way of a proper selection in the manner recognized by relevant legislation in the context of relevant provisions of the Constitution. In the name of individualizing justice, it is also not possible to shut our eyes to the constitutional scheme and the right of the numerous as against a few who are before the court. The directive principles of state policy have also to be reconciled with the rights available to the citizens under Part 3 of the Constitution, an obligation of the state to one and all, and not to a particular group of citizens. We therefore overrule the argument based on Article 21 of the Constitution.
Small 54.
And one small paragraph, 54.
Yes.
Next page. Now, my lords, it is also clarified that those decisions which run counter to the principles settled in this decision, or in which directions running counter to what we have held herein, will stand denuded of their status as precedents.
Yes, obviously, they would. Just say so.
So, my lords, this is
Constitution, constitution.
Yes.
this, my lord, covers the
Yes.
principles, or the first few principles which I have canvassed before my lords, for my lords' kind consideration, my lords.
Yes.
Then, my lords, there is another principle, my lords, on which there are few judgments, my lords. That is, my lord, normally the court cannot grant mandamus to regularize all employees or to frame a scheme, since it is a policy decision in discretion of the government. Like what has been done, that all employees, you regularize them, my lords, 7,520. It's very difficult, my lord.
Page 45.
Now, if your lordship will kindly come to page 45, same judgment.
Another.
My lord, the
Indian drugs.
your lordships, Indian drugs.
Yes, yes.
Paragraph 37, my lords. Lordship will have pleasure to see it.
Yes, please.
37, my lords.
7.
May I, my lords?
Please, please.
Creation and abolition of posts and regularizations are purely executive functions. White P.U. Joshi versus Accountant General. It was held. Hence, the court cannot create a post where none exists. Also, we cannot issue any direction to absorb the respondents to continue them in service or pay them salaries of regular employees, as these are purely executive functions. This court cannot arrogate to itself the power of the executive or legislature. There is a broad separation of powers under the constitution, and judiciary too much knows its limits.
This is precisely what we are also.
Your lordship has observed, my lord, precisely, my lords. The next paragraph also, my lord, the respondents have not been able to point out any statutory rule on the basis of which their claim of continuation in service or payment of regular salary can be granted. It is well settled that unless there exists some rule, no direction can be issued by the court for continuation in service or payment of regular salary to a casual, ad hoc, or daily rated employee. Such directions are executive functions, and it is not appropriate for the court to encroach into the functions of another organ of the state. The courts must exercise judicial restraint in this connection. The tendency in some courts, tribunals to legislate or perform executive functions cannot be appreciated. Judicial activism in some extreme and exceptional situations can be justified, but resorting to it readily and frequently, as has lately been happening, is not only unconstitutional, it is also fraught, which gave peril for the judiciary.
51 and 52. The point of financial.
Followed it. Yes.
Look, then kindly come to para 51 and 52 minutes.
Right.
51. In page 68.
68. Yes.
Lordships. One may be very large-hearted, but then economic realities have also to be seen. Giving appointment means adding extra financial burden to the national exchequer. Money for paying salaries to such appointees does not fall from the sky. It can only be realized by imposing additional taxes on the public or taking fresh loans, both of which will only lead to additional burden on the people. Then, no doubt, Article 41 provides for the right to work, but this has been deliberately kept by the founding fathers of our constitution in their directive principles, and hence made unenforceable in view of Article 37, because the founding fathers in their wisdom realized that while it was their wish that everyone should be given employment, but the ground realities of our country cannot be overlooked. In our opinion, Article 21 of the Constitution cannot be stretched so far as to mean that everyone must be given a job. The number of available jobs are limited, hence court must take a realistic view of the matter and must exercise self-restraint.
Yes.
Now, my lords, another judgment, my lords. Kindly come to page 86, my lords.
No, see, of course. ওই ভয় দেখিয়ে আমাদের প্রথমটা পড়লে পড়লো Yes,
Lordships, it's Union of India versus Ilmo Devi and another.
right.
Para 1-3, my lords, 13.
13.
At page, it starts from page, my lord,
Yes.
96. May I, my lord? Oh, I'm sorry. I'm sorry.
No, no, it's fine. You can start, Mr. Sanjay will catch up. Yes, yes, got it.
Lordships. Para 13, my lord, the observations
Okay.
made in para 9 are on surmises and conjectures. Even the observations made that they have worked continuously and for the whole day are also without any basis and for which there is no supporting evidence. In any case, the fact remains that the respondents serve as a part-time employees and were contingent paid staff. As observed above, there are no sanctioned posts in the post office in which the respondents were working. Therefore, the directions issued by the High Court in the impugned judgment and order are not permissible in judicial review under Article 226 of the Constitution. The High Court cannot, in exercise of power under Article 226, issue a mandamus to direct the department to sanction and create posts.
From applying for regulation, if there are otherwise found to be eligible. তাকে open করে দেবে সব। আমরা যেহেতু মোটামুটি করবো, some people will be left out.
Sorry, Mr. Sanjay, yes.
Look, I'm sorry.
No, yes. Please
May I
continue.
read it again, my lords?
No, need not from, you can start from the High Court in exercise of power, the last 5
Look,
lines.
Your lordships, the High Court cannot, in exercise of power under Article 226, issue a mandamus to direct the department to sanction and create the posts. The High Court also cannot direct the government and departments to formulate a particular regularization policy. Framing of any scheme is no function of the court and is the sole prerogative of the government. Even the creation and or sanction of the post is also the sole prerogative of the government, and the High Court in exercise of power under Article 226 of the Constitution cannot issue mandamus or direct to create and sanction the posts.
Here, Mr. Sanjay, this stage is apparently over because the administration has done it. But yes, it has an indirect bearing, but ultimately funding it. So this creation of sanction also comes in.
Sanction has not come here.
Sanction, yes, sanction.
Sanction has not been,
Sanction.
the post
Right.
has not been sanctioned, my lord.
True,
So-
true.
So that stage is still there, my lord.
The
Because
scheme-
the High Court said that irrespective of sanction or non-sanction,
Yes.
you pay them wages equal to that 1/30th.
So the scheme is still in court, sort of. I mean,
Yes,
unless
it's premature scheme, my lord.
Still says that
It is still states that sanction is still required by the government of India. So
Yes.
the post of sanction as also the finances are
Like-
involved.
right.
Then, my lords. There is a 14.
next judgment.
No, my lords. One more, next paragraph also some part is relevant, my lords. Even the regularization policy to regularize the services of the employees working on temporary status and or casual laborer is a policy decision. And in judicial review, the court cannot issue mandamus and or issue mandatory direction to do so. In RS Bonde, it is observed and held by this court that the status of permanency cannot be granted when there is no post. It is further observed that mere continuance every year of a seasonal work during the period when work was available does not constitute a permanent status unless there exists a post and regularization is done. Then, my lords,
There are page 100.
page 100, my lord, next judgment, That is
Yes,
State of Jammu and Kashmir and others versus District Bar Association, Bandipur.
right.
Paragraph?
Only read.
Only one paragraph, my lord.
Thank you.
Para 26, my lord.
Yes.
At page 123.
Yes, sorry.
My lords,
Mm,
the
yes.
principles will have to be formulated bearing in mind the position set out in the above judgments. Regularization is not a source of recruitment, nor it is intended to confer permanency upon appointments which have been made without following the due process envisaged under Article 14 and 16 of the Constitution. Essentially, a scheme for regularization, in order to be held to be legally valid, must be one which is aimed at validating certain irregular appointments which may have come to be made in genuine and legitimate administrative exigencies. In all such cases, it may be left open to the court to lift the veil to inquire whether the scheme is aimed at achieving the above objective and is a genuine attempt at validating irregular appointments. The state and its instrumentalities cannot be permitted to use this window to validate illegal appointments. The second rider which must necessarily be placed is that the principle as formulated above is not meant to create or invest in a temporary or ad hoc employee the right to seek a writ commanding the state to frame a scheme for regularization. Otherwise, this would simply reinvigorate a class of claims which has been shut out permanently by Umadvi. Ultimately, it would have to be left to the state and its instrumentalities to consider whether the circumstances warrant such a scheme being formulated. The formulation of such a scheme cannot be accorded the status of an enforceable right. It would perhaps be prudent to leave it to a claimant to establish whether he or she falls within the exceptions carved out in para 53 and falls within the ambit of a scheme that may be formulated by the state. Subject to riders referred to above, a scheme of regulation could fall within permissible limit of Umadvi and Vivancy. So therefore, the exception has been given there also.
Yes, yes,
Which means individual employees have to show that their case falls within that
yes.
within that exception.
Probably satisfied.
Then page 126. Now, my lord, kindly come to page 126. Only one paragraph.
Yes,
कहाँ से शुरू होता है? 126 से starting. My lord, it starts from page 126. Paragraph 28. Para 28, my lord. It
yes.
is at page, I'll just count. 137 minutes.
137, yes.
Lordships.
Settled proposition.
One paragraph.
Policy decision. Yes,
Lordships. As per the settled provision of law, the court should refrain from interfering with the policy decision which might have a cascading effect and having financial implications. Whether to grant certain benefits to the employees or not should be left to an expert body and undertaking, and the court cannot interfere lightly. Granting of certain benefits may result in a cascading effect having adverse financial consequences.
yes.
Page 165.
Then kindly come to page 165, my lords.
Yes,
Now, my lord, this is State of Bihar, page 165.
yes, yes.
State of Bihar versus Sachindra Narayan and others.
16.
Para 16 minutes.
Hmm, hmm.
16 and 17, only two paragraphs. Page 171.
State can be improved to center state.
हाँ,
The
my lord,
parallel.
हाँ, आ रहे.
Yes,
My lord, this is on the issue whether the scheme of the state can be thrust on the government of India. Now, my lord, para 16, section 6 of the act empowers the board to hold, control and administer the property and the funds of the institute. The board is further empowered to create, post and appoint officers with a condition that a post of which emolument exceeds rupees 1,000 per month shall not be created without previous sanction of the state government. Therefore, the board has freedom to create post and hold, control and administer its property and the funds. But the post carrying an emolument of rupees 1,000 per month or more cannot be created without previous approval of the state government, like in our case, my lord.
yes.
though the proviso to section 6(2) of the Act requires approval of the state government in respect of creation of post paying or pay of more than 1,000, but the intention is that any financial expenditure of recurring nature would require the approval of the state government. Therefore, if the amount of pension exceeds rupees 1,000 per month, the same could not be claimed from the state government as a right without approval. This is where I want to put emphasis.
Yes, yes.
The state government cannot be called upon to bear the burden of the pension, as such a scheme was not approved or even sought for. The provision of payment of pension in the budget of the state government is a voluntary act, not enforceable by a writ of mandamus. The release of grant is in discretion of the grantor and cannot be forced by the grantor. Now, in the present case, it will be on the budget of the government of India.
Yes.
The entire regularization burden will govern government of India. Then next paragraph. It is true that in certain financial years, as per documents on record, the amount of pension was specifically mentioned while granting to the institute, but such amount is in discretion of the state and cannot be enforced by a writ of mandamus. When they themselves gave no difficulty. There is no obligation on the state to disperse and grant the grant towards the pension amount in terms of the Act or the rules or even in terms of the resolution of the board.
Most of the judgments are
These are the principle culled out from these judgments, my lord. I don't want to make repetition of the same principle by multiplying the number of judgments, my lord. My lord, although we have enclosed certain more judgments, but most of them, my lord, rather the Umadvi is the, my lord, crux.
Yes.
And
Thank you for
all the principles has
circuit, that's a difficult otherwise actually real actually. So you are also feeling curtailing arguments and asking you to be brief. But that's the difficulty. Circuit is in our hand. That's the difficulty only. Nothing else. So, but definitely the main judgments you have already cited.
Lordships.
And so you have covered the policy decision aspect of it, backdoor entry cannot be reversed, the right of mandamus. Yes, very good.
So, my lord, precisely, my lord, I stop here so that my lord can ask the state to respond.
Yes.
And my lord, but before that, only few, my lord.
No.
I'll just.
Necessary. Allot some time for this matter for reply, if necessary.
Lordship, I'll do that. Your lordship will hear the state today itself, or
no. If you can, we'll continue. We'll continue. So your fees, then you can take up their. Then we'll hear them now.
So, your lordship, for the present, my lord, I stop here.
Yeah, if necessary.
In rejoinder,
Yes, right.
So in fact, so my lord, in substance, my submission is that the judgment of the honorable single judge, on principle, it has tried to come out of the judgment of Umadvi by citing exception of it, my lord, but it does not come out of that because it ignores many other aspects. It only takes into consideration that they have worked for certain length of service, and in earlier round of litigation, the scheme was formulated. So you are bound to accept the scheme, irrespective of its financial repercussion, etc. Nothing. But you are bound to accept the scheme. So therefore, my humble submission is
subject to correction. Paragraph found some justification given. Paragraph 34 stated. Opponents, including and 6 months, to which you have counted there were disbursements in this 300. So this was no as per the Supreme Court's order. So you have done these things. Now, understand.
And in lighter vein, my lords,
Yeah.
I just want to make one submission, my lord, that your lordship have seen now, by now, my lords have seen the entire conspectus of the first round of litigation and the second round of litigation.
Yes.
And my lord could have felt that the scheme even was prepared, my lord, was prepared because of the threat of contempt, my lord, with profound respect.
That we can appreciate.
Lordship,
Which you can't appreciate. Say, okay, yes.
I'm deeply grateful, my lords. Let my learned friend start.
Thank you so much. So, you first.
My lord, administration, one more ASG is appearing. If you want to say something.
Yes,
let me-
probably.
Yes,
Yes. Mr. Natraj is there probably.
yes.
Mr. Kumar, the Kajal, if he does not appear online. Mr. Natraj. You can start, you have had a conference, so you are comfortable enough.
It as a performer respondent because we cannot.
No, but we want to know your stand. What is your stand on this? Will not hold you liable, I mean.
What is the stand taken by the MHA?
Take the microphone towards you.
The stand which is taken by the MHA is the stand which is we are also taking. That's yes.
Of the union. Union, then you'll again be guilty of contempt. We'll refer it to the Supreme Court then. So you are more or less adopting the stand of the union,
Yes, yes.
in principle at least. Very well. Let us hear Mr. Kumar then.
Well,
You are for the Mazdu Sangh, so you are the most affected party in a
yes,
sense. Yes.
my lord, on.
Umadvi appears to be insurmountable in a sense.
No, my lord.
No, just so that you can answer and you make your own submissions in your own way. And the other point taken is we are very worried about that how far this blanket.
There is no blanket order, my lord. I will show from the.
How can they approach on the scheme? Is that permissible for the courts to do? I mean, you have to argue on that also.
Now, my lord, already there exists an office memorandum issued by the Ministry of Personnel on 7th of June 1988.
These were before the single death.
Yes, my lord. So, in terms of the said office memorandum, it says that if you are extracting the service of a regular employee by a casual employee, whether the post exists or not exists, subclause 2 says, then you have to pay 1/30th of pay. Now, in the same office memorandum, clause 10 and 11 deals with a situation where a casual employee discharges the duties of a regular employee. Under such circumstances, his such service has to be regularized with the concurrence of the ministry.
Mr. Kumar, let us come directly to that.
Yes. Can we come to
Let us come directly to that.
Yes, my lord.
That will help us.
Page number 67, perhaps, my lord. I am just 69.
69, because then we can directly advert to the issue. 69. And these were part of the writ petition.
Yes, my lord.
Other which are in the paper book. Right.
Subclause 2 deals with a situation where recruitment of beings may be made only for work which is casual or seasonal or intermediate work or so and so, which is not a full-time, for which regular post cannot be created. Now, subclause 4 deals with a situation where the nature interested to the casual worker and regular employee is the same. The casual workers may be paid 1/30th of the pay at the minimum of the relevant plus DNS allowances. Now, so a situation where a casual employee is discharging the duties of a regular employee, irrespective of the fact whether he is working against a sanctioned post or not, he is entitled for the minimum of the 1/30th. That is relevant scale, my lord.
Only the nature of work is the determinant.
Determination factor, nature of work. Then we come to subclause 10. Next page, my lord. The
Yes.
The regularization of the service of casual worker will continue to be governed by the instruction issued by this department, that is the Ministry of Personnel. While considering such regulation, a casual worker may be given relaxation in the upper wage so and so, so and so. Next para is relevant. If a department want to make any departure from the above, it obtain the prior concurrence of the Ministry of Finance and the Department of Personnel and Training. All the administrative ministry department should undertake a review of appointment of casual worker in this office under the control so and so. Subclause A says all eligible and registered against regular posts to the extent such posts are justified. All the rest of the casual worker not covered under A and whose retention is considered absent and in accordance with the guidelines are paid so and so. Now, if my lord will recollect, my lord, the division bench has taken into account 7 June 1988. Now, what happened, my lord, is 22nd of September 2017, the administration promoted a scheme saying that it is a one scheme where we have decided to 30th of pay. Now, what happened? 7 June 1988. 7th June 1988, administration had circulated this notification of Government of India saying that if you are engaging, then you have to pay. And there were several litigation by this court was directed to pay that said benefit from the date of initial engagement. So 7th June 1988 is concerned. Now in the year 2017, administration found that there were more than 7 or 8,000 persons who are working on daily wages. Administration as a measure, being a welfare state, they decided to accord this benefit. Conditions were put that it ought to be against a sanction post. They have put a cut date of 1st September 2017. I am sorry, 2017. Now we challenge that. We said that since in terms of the office memorandum 7 June 1988, which was issued by the government, that prevails as per which, because that is on the basis of a judgment by the Supreme Court in the case of Surinder Singh. So we say that you cannot contest the right and say that this would be the way. And secondly, sanction post is not the requirement in terms of clause 2. Therefore, you cannot ask for a sanction post. The only consideration would be whether a person is discharging the duties of regular. So the court accepted our argument, and the court said, because in their affidavit, the administration has mentioned about the notification of 7 June 1988. Therefore, we said, so far as sanction post, that cannot be, and so far as the date set as and when a person is engaged after 1988. Now, when the appeal was prepared by the administration, now when the appeal was prepared, the administration said we are pursuing the appeal. He said that we are pursuing with the 7 June 1988 and we are service. This was in filed from him before the judicial bench. Judgment. Can you see that portion of the judgment? Yes, sir. My lord, can you come to 5, my lord, 85 or 86? I am just placing one portion at the 85, my lord.
Yes, yes,
First paragraph.
yes.
In fact, it is submitted by the administration and affirmed that the administration has already commenced implementation of the memorandum. It is therefore on the process of framing of a scheme for regularization and under the so duly addressed mandatory within the next 3 months.
So you say your challenge was not restricted to the 2017 scheme, only, let's say 2017 circular only, but that was in the backdrop of the 1988
Yes,
one
yes.
being violated.
Yeah, that's why my single judge and the has said so.
So as we were discussing with Mr. Sanjay that this 1988 reference was divorced from the entire consideration in the writ petition, was not a subject matter of the writ petition, that is probably maybe incorrect. Because if it was in the backdrop of 88, which you are challenging for 27.
Absolutely, absolutely. Single judge recorded and function.
Yes.
And single judge has consciously said so. That 7 June 1988. Now, this was what fallen from said the
It means there are 2 days.
by the administration.
Yes.
By the
That is
administration.
where the shoe pinches actually.
Yes. Now, I will show one document, my lord, which they are aware of everything.
That is the villain day or the hero day.
The ministry, my lord. Now, my lord, when the division bench order passed, not complied, certain orders were passed in the contempt.
Yes.
Now, my lord, the moment they obtained a stay order from the Supreme Court on 4th of August, there, my lord, the division was taken place under the chairmanship of General of India.
Yes, those we'll also look into because this is
Sure, my lord.
too specific.
Yes, yes, I'm sure. The my lord, the entire case revolved around the principles which were laid 7th October 2020 by the Government of India in the office memorandum. 7th, I will place that because the 13th of December, they relied upon 7th December, 7th of 2020, my lord, which says there are three principles which has to be considered. My lord, that 7th October 2020 was issued, clarification was given by the ministry with regard to implementation of Vacancy. Now, there were three propositions. First proposition was that there is a cut-off date, 1st August 2006. Second, my lord, requisite qualification. Third, against sanction post. These are the three propositions. Now, while this discussion was going on, the Attorney General of India arrived finding that we take this three proposition and we will modify it. The word is modify. We will modify it. Instead of this date, we will choose the date 1st August 2023 because incumbents were appointed subsequent to that after Umadvi. Now, it is a circular of Government of India dated 11th December 2006, which says that you complete this exercise within 6 months. Now, that disappointments were in place, my lord. So, because the Attorney General has held that 1st August 2023, if you, then only these actions can be, no, 1st August 2023 is taken, then only such persons can be. From that, my lord, there were sanction created post. This is there, I will show from the document. Secondly, my lord, at no point of time any scheme was presented administration on the basis of the judgment passed by Umadvi. There is a recording by the division bench. In a case, I will cite that also, where the division bench has said, despite of directions issued by this court, in some cases, my lord, to promulgate the scheme, no scheme was promulgated.
Sir, Kumar, we are two questions are troubling us.
My lord.
Is that does the 2023 scheme take into account Umadvi and the riders? If the 2023 scheme contains certain safeguards, then probably we could have
No,
look into the 2023 scheme to see that Umadvi concept has been, the safeguards have been. And another question that we are putting to you, that the additional solicitor, the Attorney General, in this capacity as the Attorney General, may have advisory jurisdiction over the government. It's not binding the government. So, for other things, Attorney General's advice is necessary even. And he is supposed to be neutral in all these things. But for a policy decision, as an executive, is the government bound by the advice of the Attorney General? We don't think so.
It's not only an executive, my lord, because there,
But if he argued in court and if he considered on behalf of the government, that would take a different color.
no, it was,
There were several meetings at Attorney General that
court. And
so he appeared probably for the contender in that proceeding. So that is what he is told. There is a conflict of interest here also.
I will show those documents. My lord, I will first show my lord the scheme, my lord. My lord, can we come to the scheme, my lord? Page 118, my lord. 121, my lord. State of
Mr. Kumar, how long approximately will you take? How long more? No, we
I will
not
try-
telling you.
No, so far as the facts are concerned, I will try to conclude within half an hour.
So we were thinking this because we have not taken up this single. We have not taken up the single bench matters at all. There may be certain urgent matters we don't know. So for I mean, I'll hear you for say 10 minutes. At say 4:05, we will rise and we'll sit at 4:15 and take up and see if there is any urgent matter on the single benches also.
My lord. My
So
lord,
we will hear you up for 10 minutes.
my lord, my lord. I will just play the scheme, my lord.
You do in your own
Yes.
way, you proceed. Yes.
My lord. It's 21, my lord. 121. short title and commencement. This scheme shall be called Andaman Nicobar Casual Labor so and so. The scheme shall come into force from the date of its publication in the official gazette. Now, my lord, can we see clause 2, next page. The casual laborers daily fulfill the following criteria and regularization under the scheme. The casual Mazdoor should have put in at least 10 years of continuous service as on so and so without having protection of any interim order of the court or tribunal.
Umadvi দেখো take care করেছে B takes care of that.
Yes, my lord, it's taken care of. My lord, highest officer of the country is advice, and on his advice it was drafted. So, my lord, the kind see second one, the initial appointment of such casual labor should not be illegal, even if irregular. Such casual labor should possess the prescribed minimum qualification and age as prescribed in the recruitment rule prevalent at the time of his initial engagement in Andaman Nicobar administration. The Department of Personnel and Training, so and so has adopted principle. I have said this principle was adopted from this circular dated 7th of 2020. Clarification was given by the
Then all the safeguards are there.
safeguards are held. It is not a blanket order. This was placed, I will show from the affidavit before the Supreme Court, and my lord, these things were in the order of the Supreme 14th August, and the Supreme Court said you comply 30th of November. There are many documents wherefrom it clearly reflects that application of mine was there, and there only this was passed. And I say it is not simply sitter, an executive order. This merge with judicial bench. This is a judicial order. It's not a policy that has been followed. It's not a simply sitter policy decision. It's a decision arrived on the basis of a judicial pronouncement. And admittedly, that judicial pronouncement is not challenged.
The union was never a part.
Because here we are under Article 239.
Attorney General appeared for the LG.
My lord, I will show the 9th September. When the matter was taken, Chief Justice, the then Chief Justice Chandrachud was annoyed when they said that this is a regular practice going on. This all things has been fallen with. That's altogether different. This is a common ground. My lord, can you see the language?
Yes.
Union government. That has been recorded. Now, my lord, this, if my lord, things were record all the consideration.
Washed its hands. Supreme Court also did not clarify that. I left it open.
And my lord,
That's the difficulty. If there was a clear direction on the union government, then we could have.
no, my lord, they filed a CAN application.
There is page 270 in their CAN application before my lord. My lord will find a letter dated 20th October 2023.
কভার করেছে তিনটেতে তো উমাদেবী কভার হয়ে যাচ্ছে লিগাল অ্যাপয়েন্টমেন্ট এডুকেশন qualification 10 years continuous service all three are covered.
What it?
Yes, no, not yet. Just give us a supplement. Yes, thank you. This 20th October 2023. Yes.
This is a letter by Ministry of Finance.
Hmm.
Now, my lord, it says this is October 2023. I was surprised to know that the government of submitted an affidavit in the Supreme Court of the case specifically the government. Apparently, without consulting Ministry and so without consulting Ministry of Finance, some of the option proposal of the affidavit and option to impose heavy and long-term financial cost position, therefore requested MHA to implead itself in the case on priority so that the financial interest of the union so and so. They have not impeded. Despite the Ministry of Finance written a letter to the Ministry of Home, they were watching, my lord. And subsequently, they can raise this issue that we were not a party to that. Now, my lord, can we see this scheme, my lord? If my lord sees, I have read just 122. If my lord sees, there are all other aspects which were taken into consideration. Now, my lord, can you see clause 4? And my lord, this scheme, my lord, reflect that it is on the basis of the order passed by this court. My lord, can you see, my lord, clause C, thereafter it said so, they should be put in so and so. Honorable High Court at Calcutta in MS category remove so and so, so and so. The order of the judicial order was taken into account. It is not simply a policy decision. Now it says the personal department under Numerical said publish the provision list of casual labor daily rated based on the data uploaded in the DRM by the various department, and claim objections should be invited through their respective head of department within 30 days from the date of publication. Every casual labor daily rated would fulfill the condition as so and so contrary to file his claim and objection to the respective department. The publishing of the so and so list of documents to be submitted by casual to the concerned head of so as to ensure their eligibility. R.S. under self-attested certificate copy of all engagement order in chronological order in support criteria of as on so and so, so and so.
The bullying which Umadvi gave start highlights. Before you take my lines. So the following person that 119, therefore. Sorry, they have taken care of all the points, even for the creation of the supernumerary, because if there is no vacancy.
Everything.
I will not use it. But this is based on that.
Maximum.
Even if my lord sees clause 8, my lord, they have even considered those cases where it cannot be regularized. So it is not any blanket, administration has taken due process, adopted due process, and thereafter, my lord, this scheme was promulgated. So this scheme have all the requirement which was carved out in Umadvi, my lord.
Who are the signatories to, what was this? No, this was only security. Secretary personnel of what? Andaman?
This was, I will show that page also. The administration in principle has approved this scheme, page 133. I can show that. This is another document, but only for this purpose I can place it, my lord.
No, we'll come back to this, no difficulty. Let us see that once.
My lord, can we come to page?
Because apparently the paragraph 8 casts a mandate on the personnel department also.
Yes. My lord, 133 last paragraph, my lord.
133, yes.
Again, my lord will find in compliance with the order.
Yes.
That so and so passed by the Supreme Court and read with the DOPT, a scheme for regularization of has been drafted by the administration, which has been approved in principle by the administrator.
Administration.
Yes. By the administrator.
Stops there.
No.
Because he was in content. And you are the architect.
My lord, concurrence is required, but what I am now, my lord, we have.
Entire financial burden will go on the union government.
My lord.
Concurrence is absolutely necessary.
Concurrence is necessary because it is.
Because when you have limited resources, you have to have choices. I mean,
my lord, the payment of 1/30th to 300 crore was made.
yes,
So
but they
my lord,
cannot make it a.
After that, very bigger amount is left. Now, my lord, I will tell my lord this. The Supreme Court, what all issues my learned raised. First of all, my learned says there is no sanction force. I will show from their affidavit before the Supreme Court, they have said 4,400 sanction posts are there.
Their affidavit means union
Administration affidavit.
administration.
No, my lord, the post is created by the.
Administration.
No, union government. Post is created, sanction posts are there. Those were created long back. Even I have annexed a document showing more than 4,000 posts are lying with the administration. And even the administration has set on their affidavit before the Supreme Court. There is no departure from the said fact, my lord. The post exists. 4,000 odd posts administration say exist.
So, Mr. Kumar, we have touched most of the facets of this 2023 scheme, but we'd like to point out, please come to page 124, that somewhere it's written, no, sorry, where it's written that it will be subject to concurrence. 135, no?
134 is subject.
134, that is 134.
No, 134 speaks of subject to concurrence.
My lord,
And you were supposed to.
because it's a UT, my lord. We cannot be, we are not state, my lord. All the fund has been given
And the
by
compliance report has to be filed. That's what they said in 134, compliance report, because until unless this draft scheme is being approved, then it can't be done. So that has not been, yes.
And my lord, Article 239, my lord, the precedent administered and duty.
Yes,
Duty is administered by
but it has its autonomous administration also. Has its autonomous
financial conference has to be, my lord. Before Umadvi and after Umadvi, on the direction of the courts, schemes were promulgated by the court. Before and after. And now, my lord, what all argument my learned friend has made, those all argument are rooted in the recent judgment of the Supreme Court, where the Supreme Court says sanction post is not required, financial burden should not be seen. Once you are extracting a service of a person for a regular nature for years together.
equal pay.
No, my lord, regularization. I have cited all those judgments, my lord. I have served a copy to my learned friend earlier.
Very well.
So all those judgments are there, which says, my lord, even sanction post is not required.
We will also have to meet the other aspect of the argument of the union, that the policy decision, how far we can.
My lord, I say it's not a policy decision at all. It's a decision on the basis of an order passed by the judiciary.
In which they were not a party.
No, my lord, but my lord, inter-party binding. But the thing is that, my lord, already in terms of that order only, the administration has promulgated a scheme.
Up to
Now-
the administration level, we fully agree with you. Administration cannot deviate from that. Union was not a party there. You should have implemented the union as a party, but we can understand because your grievance was against the administration. Anyway, we'll look into that. We'll look into.
Doesn't, my lord, what is their ground?
We have little scope of discussion. Let us confine ourselves to this. Yes.
Their ground for rejection is that it will impose a heavy financial implication. Now, in a recent judgment, Supreme Court said only because financial implications are there. My lord, after Umadvi, my lord.
No, if it's a duty, constitutional duty or duty cast by some statute or by some obligation which they are the architect of, then financial burden itself may not be a mitigating factor. But here they were neither a party there, nor is there any statute directive under which they are compelled to, they have to sanction this scheme or whatever. So therefore, I mean, they have a valid argument in saying that it's a
I say,
financial aspect is their prerogative.
well, I say post was created by them. There is a sanction post line. Funds are being given for.
So we'll look into those documents. So this 2023 scheme we have finished.
Yes.
So now we'll look into this because something else 2020.
So, my lord,
Yes.
The meetings which were held and the
Yes.
recommendation of the Attorney General.
That we'll also see, and the sanction post these documents in a nutshell. We'll please complete it. We'll keep it tomorrow on Monday for within half an hour. So we'll keep it at the top so that we can display.
My lord,
No, Mr. Sanjay is only there.
my lord, and I have already given the copy of the judgment.
Very well.
And I will deal in a note with regard to the judgment which they have cited. Just give the facts and why it is not applicable in my.
Very well, but stay your hands. Please stay your hands on this impugned order till we pass because we'll decide the appeal itself. On Monday we'll hear you and then conclude arguments and then just keep it. Judgment will be reserved and we'll as soon as possible before we leave the islands we'll pass the judgment. But please stay your hands in the meantime so that you don't have to pass a stay order on the. For the timing we're not passing any stay order, but stay your hands. Don't implement the impugned orders. Mr. Sanjay will come back on Monday. We are keeping it at the top 10:30 so that you can conclude this. You are muted. From our end,
I'm
yes.
sorry, my lords, only, my lord, instead of Monday, can it be on Tuesday, my lords?
It can.
Lord, Tuesday, because Monday I have some personal difficulty, so I'm making this.
Monday. Sir, Sanjay will keep it on Monday. We'll conclude the argument there. He will conclude the arguments, Mr. Kumar. If you need speak on Tuesday for you. You please keep engineer.
My lords, actually,
Very good, very well. Very well. I will keep it on Tuesday.
lordships, I'll be great.
Short as possible. And Mr. Sanjay, if possible, please just furnish a bullet arguments. What?
Sorry,
Can you please furnish a bullet of arguments on the arguments which you have made? A bullet point, a short, just the main aspects of the matter. Read notes.
lordships.
And the next day,
Lords,
and make your arguments according to that.
Lord,
You also,
yes. Lord, I've been messaged by the ASG, Lord, he will make certain submissions on Monday.
We'll give him 10 minutes.
Yes.
You don't have.
I inform.
Mr. Vinu Kumar, I request you to make curtail your submissions as much as possible so that you can touch other matters. So we'll give it on Tuesday.
Deeply grateful.
Thank you. Hardened part for further hearing is the matter on April 21, 2026. To be taken up at 10:30 a.m.
Blair.
Grateful.
So we'll part and we'll meet, we'll sit singly after 10 minutes.
Deeply grateful.